13521 of 2013.
I had seen this. Certainly.
In the result, this writ petition stands dismissed, but in the circumstances, there shall be no order as to costs.
My page 113 annexed to with the input
Page?
113 113
Yes.
annexed to 2 mile.
Yes, please. Page 71.
My lord, there is a problem in that page, my lord, that is not readable. I have got it typed, but two lines I could not get it, my lord. For that, I am unable to keep that typed copy, my lord. And the entire case is based on that advertisement.
That case is based on?
That advertisement where the eligibility criteria has been fixed. And I have got it typed.
Which page is that?
Page 71. I have to submit that original copy, my lord, because I cannot give that copy typed, which the 2 lines are missing in my. If you also may permit me some time that I can file that. But this has been annexed on the basis of that advertisement, which was annexed to the writ petition.
No, but what is the issue involved?
Yes, ma'am. There I have got some 2 lines are missing, but substantial portion that which I am relying that it's also typed. I can give.
No, what is the issue?
Yes, my lord. Yes. Issue relating, my lord, termination of service. An advertisement, this advertisement was issued for recruitment of contractual teachers. In this advertisement, certain eligibility criteria was there. What was the eligibility criteria? For a moment, your lordship, because the 2 lines are so I am not submitting that. Your lordship may see that legible copy.
2 lines from the top.
No, my
72.
second page, that is not.
Page 72.
That is not relevant. But anyway, that I cannot say that I'm typed copy, complete typed copy. Your lordship may say what is required here.
This must be in accordance with the resolution.
Yes, your lordship may see.
The eligibility criteria must be supported by.
No, not resolution. This is in accordance. This is a contract teacher. The lordship may see eligibility D.
Yes.
Lordship got it.
Yes.
As regards eligibility of candidate for engagement of contract teachers, she must have obtained bachelor degree in arts science along with a degree of bachelor of education.
So where are reading? Eligibility in order to be eligible.
But in order to be eligible, I am reading at D.
D.
D, my lord.
B. Bombay.
D for
ABC.
Bombay.
No, D for Delhi. That's
Delhi.
towards the end and the
As
middle of the
Yes.
paragraph.
That's you got it.
Yes.
As regards eligibility of candidates for engagement of contractual teachers, she must have obtained bachelor's degree in arts science along with a degree of bachelor of education from a recognized university for being considered as a trained graduate teacher. These are the qualifications prescribed in the advertisement for the post of trained graduate teacher on contractual basis.
Yes.
He does not have that training qualification, that he does not have that BD qualification. He has the qualification of BA with Shiksha Shastri from Rashtriya Sanskrit Sansthan. But treating it as equivalent, though there is no provision in the advertisement equivalent qualification, treating it as equivalent with BD, he was selected for the post of contractual teacher. Well, yes, ma'am. He was appointed in the year 2011. But when at the time of regularization came, all the documents were verified, and it was found that he does not have that qualification as per the advertisement. So his appointment was cancelled. That was the subject matter of challenge.
Which appointment was cancelled?
This contractual appointment.
Contractual appointment.
Because he was not regularized. When case for regularization was come,
No, you have the policy that after 6 years
yes,
of this contractual appointment, they will be given
regular appointment.
regular appointment.
Yes,
That is in formal nature.
yes, that
Resolution.
yes.
That
Accordingly, when at the time of regularization, it came to the notice of the government
after 6 years.
after 6 years. When it came to the notice of the government, I will show that document. In 2019, it was found that he is not that requisite qualification. Government recommended because that appointment is not in accordance with, so that appointment is
So
void.
what has been held by learned single judge?
Lawrence Single Judge has held since he has continued by virtue of interim order, and he had the equivalent qualification, relying on one judgment of this honorable single judge that directed to allow him to all the service benefits.
Has he said that Sikhya Shastri is equivalent to
Yes,
bachelor's
yes.
degree
Yes,
in arts?
yes, that enter case is that. If your lordship will hold that there is an equivalent clause in that advertisement, then we don't have any case. And there was no equivalent clause in that
So
advertisement.
first of all, bring that advertisement.
Yes, my sir.
Clear
For
copy of
that
the
reason, I was praying for some time because I have to give that in original advertisement. Unless that original
Do you have a copy of the original advertisement, madam?
I do not have it. My learned friend has it.
You are representing whom?
And I am also one of the respondents in one of these batch of writ appeals which have been allowed.
So we permit you to file an affidavit
Madam, we will file.
bringing this on record,
Madam,
or whether otherwise legible copy is there on record.
yes, that is there on record.
So original copy hai kya?
In fact, Lordship, the particular line that he's relying upon, that there has to be a degree in Bachelor in Arts and a B.Ed, Lordship, that line is very much visible. And he's relying, his whole case is on those two lines.
So, but what answer do you have?
Lordships, in fact, this is B.Ed. The B.Ed is from a recognized university and it has been held by NCTE, Lordships, the National Council for Teachers Education, that this is B.Ed. Lordships, equivalency, there Utkal University says it's equal, but there are Lordships, NCLT and other Lordships
No,
departments.
how
which
do
were-
you say that? Where
Lordships,
is-
I would take Lordships. So Lordships may have page
So
49.
that is the only question.
yes, ma'am. That is
Your submission is that the qualification which he has, or he has, or she
C.
She
Three,
has.
three of
she has, which,
One of them
the
is.
qualification which she has is not a B.Ed qualification.
not
Just
not
a
a-
minute.
yes. Sorry.
Just a minute. Is not a B.Ed qualification, one. And two, there is no
Equivalent.
equivalence in the clause in the clause in the advertisement. So therefore, the qualification which she has, even if that is equivalent, that cannot be treated to be
A bid.
that treated to
Terms
be
of the
a
advertisement.
qualification in terms of the advertisement.
Right.
This is what you
Yes,
submit.
Yes.
So
That is the only submission.
yes, my lord. To fortify this much, your lordship may I bring to my lord's notice to paragraph 5 of that read petition. Read petition filed by him. Paragraph 3, my lord.
29393.
Yes,
First case.
yes, first case. Paragraph 3.
Page 20.
Okay.
Page 20.
Paragraph 3 is at page 4. The 4.
Page 4 of the
Internal page 4.
Writ petition. Internal.
page 4 of the writ petition.
Page 4 of the writ
Internal.
petition, internal page 20 of the writ appeal. Which your lordship is
All
posted.
right.
There it is his averment. This is a equivalent qualification.
See it.
No, but you see in second sentence.
Yes, ma'am.
Shiksha Shastri bracketed B.Ed course.
Yes.
Yes, he has written that. Shiksha from Rashtriya Sanskrit deemed university established under the Human Resource Development Government in the year 2000 from C. Sadasiva campus, Puri. The Shiksha course imparted by the Rashtriya is recognized by for teachers. Besides various state created under Odisha University, Utkal University,
All
Baroda.
right. So let us understand from her what is her subject.
Yes, ma'am. That again he has relied one judgment of this honorable court. I'll bring to that notice, my lords, whether he is applicable under that or not.
No, even whether that is applicable or not is one question. The question is whether she was possessing the qualification of
Yes.
B.Ed or not.
Yes, ma'am.
Equivalent to B.Ed shall not be considered because that was not in the advertisement. The
I'm not
qualification
sure.
must be B.Ed.
I would take this honorable court to the annexures to show that it was a B.Ed. May I draw the attention of this honorable court to page 49?
Page 40.
49. This is to be published in Gazette of India, Part 3, Section 4. This is National Council for Teachers Education, which is a statutory body of the Government of India. And what does it say? And this talks about the university. The university is
Page 49 of
of the appeal.
appeal.
32 of the writ petition. Yes, 32 of the writ petition.
All right, we are there in
Would Lodges want to know the PDF page? I have the PDF page number also. That would be page 57, PDF.
Writ petition Annex 3.
Writ petition, Annexer 2.
Annex.
Annexer 2, running page 32 of the writ petition and corresponding page is 49 of the writ appeal.
NCT.
Yes, this is NCTE, which is the National Council for Teacher Education. And that's a statutory body for the Government of India, no less. And preamble?
where is it?
Writ petition.
Writ petition.
Page 4.
Annex 2.
The preamble. Rashtriya Sanskriti Sansthan, that's the university from where I've got my B.Ed course done. The Rashtriya Sanskrit Sansthan deemed university, Sri Sadasiv campus, Puri, central government institution coming under the MHRD New Delhi, has been granted recognition with an intake of 100 students for B.Ed course. So, Lordships, the NCTE itself clarifies that it's a B.Ed course. It does not say that there's an equivalency of B.Ed.
This Sri Sadasiv campus,
Yes.
Puri.
Yes.
And she is qualified from this.
Yes, page 43. Page 43 is the certificate. Your lordship straight away come.
Yes, Lordships. She's certified. She's taken her B.Ed from there. Thereafter, page
No, where is your
48?
specific?
Page 43.
Just a minute.
No, madam, page 43.
Either of the two.
Yes,
You decide.
yes. Well, civil.
You can take
Civil,
it.
civil.
We will give you also opportunity.
Well, civil. Naturally civil. Well, I beg apology. I beg apology for intervening.
The previous page.
The previous page,
Certificate.
that is the Rashtriya Sanskrit Sanstha, Sri Sadasiv campus, what Lordships was just asking. So it's a B.Ed course. This is to certify that Shiksha Shastri, B.Ed course. So here also it says it's a B.Ed course. And thereafter, of course, what my learned friend was suggesting the page, I'll take Lordships to that page, which is page 43.
43 of
Page 43 of the writ appeal.
writ appeal.
Yes.
What is the page in?
27 of the writ petition.
27 of the writ petition.
27 of the writ petition.
27 of the writ petition, Lordship. So this is Rashtriya Sanskrit Sanstha, New Delhi. That's the university where I have graduated from. Deemed university, established under the Ministry of Human Resource Development, Government of India. Lordships would see in Hindi it's written Shiksha Sastri, Pariksha
Yes, Mr.
and
We
B.Ed
don't find
is,
any merit in your.
And if your lordship will hold that he has a bid, I have no case.
No, it's clear. If say name of the institution is mentioned, Rashtriya Sanskrit Sansthanam,
Well,
you say that unless someone has qualification
Being-
from an institution
yes, my lord, that
or from an institute, and because in place of institution Sansthanam is mentioned, therefore that is not the qualification of.
B.Ed.
Okay.
Very true technical. True technical. Otherwise, the persons not keeping the process in these institutions. What will they do?
Yeah, yes.
What will they do?
And it is clear, NCT is the final body.
the lordship.
Yes, that's all.
Well,
Our BA qualification is question, not question.
No, BA co-
Only BEd.
only, I am not questioning BA qualification,
Sir.
only BEd.
BEd. And what is the post?
she's a
Contractual
TGT,
teacher.
it's a trained
TGT.
graduate teacher. Yes, contract teacher.
In
trained
particular subject or
That was for
TGT
past
Arts,
6
not-
TGT Arts,
8 I
TGT
would
Arts?
say.
Oblex.
Which page is this, NCT?
Page 49 of the writ appeal, which would be page 33.
32,
And
30
your qualification, certificate,
43.
43.
43 in writ appeal.
27 of
Yes,
the writ
sorry,
petition.
sorry, 40.
Swarnarekha Raut case? What is?
They are also, honorable, this honorable court had already
Swarnarekha Raut
decided.
case, Page 98,
Yes, that also decided already on this point.
single bench.
Single
judgment
judge,
of this
single
court.
judge had decided. And with this,
Taking into consideration NCT.
No, madam, that was equivalent. In that case, equivalent.
that equivalent,
So it's better to, this matter is on, this
Better
case is on a better footing.
Well,
yes.
Page 98, read the appeal. Page 98. In the read the appeal. Page 98, Swarnarekha Raut case of single bench of this court. Exactly on this point. Taking note of NCT and other guidelines.
Same qualification.
Panel 6 lordships.
What
would
is
be
that
relevant.
qualification? Shiksha Sastri.
Same qualification.
Shiksha
Well,
Sastri.
same.
In
Very same
conclusion,
qualification.
sir,
The petitioner possesses.
in conclusion, therefore, the petitioners in the aforesaid writ petitions who have acquired BA degree from an university
Right.
and thereafter have acquired Shiksha Sastri degree
Right.
shall be considered for the post of trained graduate arts teacher
Exactly.
in the aforesaid 3 districts.
Exactly.
So that is the conclusion.
That is the conclusion.
So when was that decision rendered?
Yes, yes, same.
This
When?
decision was rendered in 2009, I think. I just
2011.
2011.
10/5/2011. WPC number 6796 of 2011.
That is
Did
the,
you-
for the post of
No,
Shiksha Sayak.
single bench.
No,
Single
the,
bench.
the ratio, the principle of law is.
If the state accepted my decision.
What is the position now?
My lord, state has accepted and my lord, if your lordship permits, my lord, not only state has accepted this qualification, in all subsequent years, state is also making these persons having this particular qualification also eligible for this particular post, and they are also employing. Moreover, in the very same advertisement, at least I can demonstrate, I have given that part, which is part of the record, 10 of such candidates who possesses the very same qualification of Shiksha Sastri from the very same Rashtriya Sanskrit Sansthanam, they have been regularized in other districts in portions of the very same advertisement. But we have been ignored.
This advertisement is also of 2011.
No, that
And
is
this
regarding,
judgment-
that is regarding Shiksha Sahayak.
No, straight and no. But with regard to, I am talking about the very same advertisement which you
So
are.
counsel, you are neither allowing him to argue and not her.
Sorry.
And as we have understood, the point is very simple.
Well,
That is going in your favor. Why
Yes.
should you?
no. Well, I am not. I'm answering.
No, you are showing much anxiety. Why are you so anxious about your client? What?
In the present intra-court appeal, the state of Orissa has put to challenge an order dated 14/9/2023, passed in WPC number 29393 and 33004 of 2020. There are two appeals.
3 appeals, ma'am. 4 appeals.
In the present state of appeals.
In different rate petitions, the question is same.
Disposed of by common order.
Sara appeal.
Common order.
The state of Odisha has put to challenge the orders and convention for each of these of the appeals.
Page 97, do you press this writ appeal?
In that I can clarify that. In page 97, that is regarding Shiksha Sahayak, and there was an equivalent clause.
Shiksha Sahayak, sir. Shiksha Shastri of Rashtriya Sanskrit Sansthanam, Sri Sadasiv Campus, Puri is considered equivalent to B.Ed. NCTE, also has recognized Shiksha Shastri B.Ed course of the aforesaid institution by its letter number such and such dated 2005.
Yes.
97, Directorate of Teacher Education and SCERT, Odisha, Bhubaneswar. What more you want?
That is that I am not that has been declared as equivalent.
NCT
If
does not say.
unless it is declared as BEd, that is equivalent here. But
Too technical.
NCT, that when your lordship has said that the NCT has said that this is BEd, then I have no case. Once it is equivalent, I have a case.
The facts relevant for adjudication of these appeals are brief. There was an advertisement issued under the signature of the Director of Education, Odisha Bhubaneswar, for engagement of contract teachers in upgraded government high schools during the year 2010-11. Clause 2 of the said advertisement prescribed eligibility criteria. Stop. Eligibility criteria. Subclause D of which is relevant and is being quoted here and below. Stop. The respondents herein were the writ petitioners, admittedly had the qualification of Sikhya Sastri.
Well, Shiksha Shastri from Rashtriya Sanskrit Sansthan.
Sikhya Sastri awarded by
Rashtriya Sanskrit Sansthan.
Rashtriya Sanskrit Sansthan.
Rashtriya Sanskrit Sansthan bracketed a deemed university, or bracketed deemed university, comma, Sri Sadasiv Campus Puri, bracketed Odisha. So stop. Treating the said qualification to be a valid qualification for contractual appointment in the light of the said advertisement, the respondents were engaged on contractual basis.
Well.
Stop. Few years thereafter, when the department was considering the cases of regularization of services of the teachers engaged on contractual basis, including the respondents, comma, a question arose as to whether the respondents did have the B.Ed qualification or not in terms of subclause D of clause 2 of the advertisement. So stop. In the opinion of the appellants, the respondents did not possess qualification of B.Ed requisite under subclause D of clause 2 of the advertisement, and accordingly their services were decided not to be regularized. Stop. The department was of the view, state government concerned department of the state government was of the view that the engagement of the respondents on contractual basis pursuant to the said advertisement itself was wrong, as they did not possess the essential requisite qualification. Stop. The Services of the respondents were thus not regularized, which made them approach this court by filing writ petitions giving rise to WPC. How many cases?
In this case, the 2 cases are there and 2 other cases are there. 4 cases.
4 cases are there. Those cases are listed.
Yes, before my lords.
Oh.
Your lords,
Can you-
turn to 113 page, there is the number. 2 numbers in the present case, so far as present respondent is concerned. He has approached in 2 cases. Why in 2 cases? In 1 case seeking for regularization, another case notice was issued for termination. He has challenged the termination. So 2 cases he has filed, and another 2 applicants who are similarly situated, they have filed 2 cases. In 2 cases, they are covered by this order.
Lordships, prior to filing of this writ petition, if I just make just a little background, Lordships, when her case was not regularized, she had approached this Honorable Court in 2019. At that time, this Honorable Court had directed the concerned authorities to look into her case. And when they did not, she had also filed a contempt case at that time. And that contempt had also been disposed of, giving the state 6 weeks' time to decide the case.
In
And
compliance with
thereafter, they gave
Just a minute, where is that?
Your lordship, you can find it annexed, sir. That was,
Which made them approach this court by filing
yes, ma'am.
a writ petition.
101. Page
Where is
1.
that order?
I'll just give.
Page 101.
Page 101.
My lord.
Yes. WPC 20667 of 2019.
All right. Made them approach this court invoking writ jurisdiction, giving rise to approach this court by filing a writ petition, giving rise to WPC number 20667 of 2019 by Rashmi Mishra,
Rajlakshmi.
Rajlakshmi Mishra, bracketed, respondent in which case?
In the past case.
First case, Lordship.
Respondent Rajlakshmi Mishra, a respondent in WA 3083 of 2023.
And also 293 and also WA 3081 of 2023. Same applicant.
The next case.
Same applicant, 2 cases. 3083 and 3081.
Said writ application was disposed of by an order of this court dated 4/11/2019, asking the opposite parties therein to consider and dispose of the representation filed by the respondent, taking into consideration a recommendation made in Annexure 8. What was Annexure 8?
Lordships, that was a recommendation which
The
had been made
screening
by the
committee.
EEO Koraput for her regularization.
Annexure 8. Recommendation made by the DEO Koraput.
DEE, my lord.
DEE.
District Education Officer.
DEO.
DEO.
This is what we are.
Yes.
DEO Koraput, which was Annexure 8 to the said writ application. So stop. What happened thereafter?
That was
The state
rejected.
did not comply with the order, so we had to
The-
file a contempt petition.
As the said order was not complied with, Raj Lakshmi Mishra had preferred
Case 1447 of 2020.
contempt petition giving rise to contempt.
COMTC?
CONT
It's 1447 of 2020.
1447 of 2020. So stop. It
Thereby rejected, or case was rejected.
appears that the case of respondent Raj Lakshmi Mishra was rejected by representation of Raj Lakshmi the representation of respondent Raj Lakshmi Mishra was rejected. So stop. She filed another writ application giving rise to another writ. How two writ applications?
Thereafter, my two writ application 29393 and 33004
By whom?
by Rajalakshmi. So challenging that order, that rejection order in one writ petition. You'll ask me that 104 is the rejection order that was challenged in one writ petition and another for regularization. So both the matters are taken up.
The respondent thereafter filed two writ applications giving rise to WPC number 29393 and 33004 of 2020 before this court, taking a plea that she had the B.Ed qualification duly recognized by the NCTE, and therefore she fulfilled the requisite eligibility condition under subclause D of clause 2 of the advertisement. Stop. A learned single judge of this court by an order dated 14/9/2023 allowed the writ application in relying on a previous decision of this court in case of Vikas Mohalik versus, that is the case, Vikas Mohalik versus
State of Odisha.
State of Orissa and others, reported in 2022 volume 1 ILR Katak 108. So stop. It is noteworthy at this juncture that this court, a single judge of this court, in case of Vikas Mohalik versus State of Odisha, that in case of Vikas Mohalik bracketed supra, it is noteworthy at this juncture that in case of Vikas Mohalik bracketed supra, a learned single judge of this court had held in paragraph 27 and 28 as under, while dealing with the qualification, same qualification.
No, my lord, that is not. That is not that case.
That is not so.
My lord, that's,
There she was a Shiksha Sahayak.
It is so.
that was not the case.
We have to independently.
Relying on a decision in case of Vikas sentence के पहले का sentence.
In case of
It is not in dispute that the state of Odisha did not question the correctness of the said decision in case of Vikas Mohalik. You were referring to which? This is the judgment you were referring to. This was only Supra. So stop. Be that as it may, Supra. No, let's go. Learn single judge in the order dated 14/9/2023 has held he did not deal with the qualification aspect. No. Hearing on behalf of the appellant has submitted that learned single judge ought not to have allowed the writ application based on the decision in case of Vikas Mohalik bracketed Supra, since the respondent did not have the basic qualification of B.Ed. A requisite under subclause D of clause 2 of the advertisement. Full stop. MS Rajdeepa Behura, learned counsel appearing on behalf of the respondent, has argued that has taken us to a notification issued by the National Council for Teacher Education, bracketed Eastern Regional Committee, dated 31st, which is
August
31st
2009.
31st August 2019.
2009.
9.
Yes.
To contain that the NCTE had, in exercise of the powers vested under section 15 bracketed 3 bracketed A of the National Council for Teacher Education Act 1993, had granted recognition to Rashtriya Sanskrit Sansthan Deemed University, Sri Sadasiv Campus, Puri, for conducting B.Ed course of 1 year duration with an annual intake of 127 students. Full stop. She has thereafter drawn our attention to the certificate which was issued in favor of this is your certificate.
Yes, Lordship.
Where is your name?
Which is page 43.
What is there at page 43?
This is Rashtriya Sanskrit Sanstha, Deemed University, B.Ed, Shiksha Shastri Parikshalaya, Lavdhan Ka Patra.
Page 43, your certificate.
That's the certificate.
क्या लिखा? Issued in favor of the, this is provisional
The
certificate.
provisional is page 44, 43 and 44.
43 and 45. Marksheet is 43.
And 45.
क्या लिखा?
Yes. Is three and 45.
44 is the provisional issued on 31/7/2009.
Drawn our attention to the certificate issued by Rashtriya Sanskrit Sansthan. It's in New Delhi.
It's established under the Ministry of Human Resource Development.
In the table right hand side, first block, Rashtriya Sanskrit Sadasiva Campus Parisar Puri.
Where is that?
Page 43, you will also see the table.
Yes.
Yeah, in the right hand side, the first block.
All right.
परिसर नाम राष्ट्रीय संस्कृत संस्थान
All right.
मानित विश्वविद्यालय.
So he has certificate issued by the Rashtriya Sanskrit Sansthan bracketed Manit deemed university bracket close Sri Sadasiv Parisar Puri,
Yes.
by which Shiksha Sastri Pariksha Labdhank.
Labdhanka.
Lavdhanka
Sorry.
Patrami.
Patram.
This is something else. He has drawn our attention to the mark sheet of his offer of the respondent's B.Ed qualification as a student of Rastriya Sanskrit Sansthan bracketed deemed university Sri Sadasiv Parisar, Puri. So stop.
That's that. Sure. 47.
Attention has also been drawn to a certificate issued by Rastriya Sanskrit Sansthan bracketed deemed university granting her Shiksha Sastri bracketed Bachelor of Education qualification. Full stop. She has accordingly submitted that the state of Odisha had wrongly declared her ineligible, declared the respondent ineligible to be appointed as contractual as teacher,
On contractual basis.
Trained, graduate teacher teaching
graduate
on
teacher.
contract basis.
on contractual basis on the ground that she did not hold the B.Ed qualification. So stop. She has also drawn the court's attention to a single judge decision of this court. Where is that?
Swarna Rekha, it is
98. Page 98 of
page 98.
In case of
Page 98.
in case of
Surnarekha Raut.
Swarna Rekha Raut and others versus State of Odisha and others, dated 10/5/2011, rendered in 6796 of 2011, wherein this court clearly laid down
Para 6 is
that the in paragraph 10 that the students of जो संस्थान है नाम who have acquired BA degree from an university and thereafter acquired Shiksha Shastri degree shall be considered for the post of trained graduate arts teachers.
शिक्षा सहायक मतलब
Shiksha?
सहायक
It is not Shiksha Shastri. It's not Shiksha Sahayak.
पोस्ट ऑफ शिक्षा सहायक
It's for the post of Shiksha Sahayak.
It's acquired BA degree.
They've acquired BA degree.
acquired BA degree for the post of शिक्षा सहायक
Graduate arts, teachers.
No, in para 10 it is
No,
mentioned Shiksha
whether BEd qualification was required or not.
Sahayak. It was.
In Swarnarekha, I have read to you. Again, I am reading to you. Para 10. Listen carefully. In conclusion, therefore, the petitioners in the aforesaid writ petitions who have acquired BA degree from an university and thereafter have acquired Shiksha Shastri degree shall be considered for the post of trained graduate arts teacher in the aforesaid 3 districts.
Let's make
That is the conclusion.
para 2. What are the subject matter?
Para 10,
Para 10 शिक्षा
that is what
Yes.
we are saying.
para
You have accepted this judgment,
But
but it is not reviewed.
that post of शिक्षा सहायक, so we are
Maybe. But now the
All right,
question is
we'll
whether
consider your contention. According to you,
I am not disputing that.
no. We are duty bound to deal with each and every aspect.
No.
According to you, that was in relation to Shiksha Sahayak,
Yes.
therefore. Learned AGA has countered the submission advanced on behalf of the respondent on this point with reference to the case of Swarnarekha Raut, bracketed Supra, and has attempted to distinguish that case with the case in hand on the ground that the said case that Swarnarekha bracketed Supra was a case relating to appointment as Shiksha Sahayak.
Paragraph 2 of that judgment.
Yes. Shiksha
para
Sahayak.
3 also you read.
Shiksha Sahayak. Stop. Next. We have heard learned counsel for the appellant. Appellant is one appellant and learned counsel representing the respondents. Stop. The sole question which requires determination by this court in the present batch of writ appeals is as to whether the whether a Shiksha Shastri degree obtained from, I'm again forgetting the name of that institution,
Rashtriya Sanskrit Sansthan.
Rashtriya Sanskrit Sansthan,
Deemed University, Sadasiva campus.
bracketed deemed university, so and so Puri. Your what sentence? Only it's
Small question we did. I just can present back the
is BA degree or not. So stop. Next. At the outset, we reject the submission advanced on behalf of the appellants that the decision in case of Swarna Rekha Raut, as decision of this court in case of Swarna Rekha Raut, has no application for the present case. So stop. Present case only for the reason that the said decision, the said case related to appointment as Shiksha Sahayak. So stop. Paragraphs 2 and 3. Paragraph 2 of the said decision is relevant and is being quoted here in below. Quote. Apparently, the appointment to the petitioners of this court, after having taken note of the public notice issued by the NCTE, paragraph 6, NCTE conclusively held in paragraph 10 as under. First off, it can be easily discerned from the question which the court had posed to itself in case of Swarna Rekha, and the answer to that this court had reached a conclusion that Shiksha Shastri degree is a valid degree for the post of Shiksha Sahayak. Full stop. Shiksha Sahayak.
Yes.
Graduate
Yes.
teacher.
Shiksha Sahayak. Full stop. The court specifically held that that Shiksha Shastri degree shall be considered for such appointment. Full stop. Next, it is also not in dispute that the state government has accepted the said decision rendered on 10/5/2011 in case of Swarna Rekha Rao, which has never been challenged. Full stop. Next, the state government has ventured to put to challenge ventured to raise the dispute again with respect to the qualification of Shiksha Shastri obtained from that institution as not a B.Ed qualification for the purpose of appointment as which teacher?
Contract teacher.
Trained graduate
Graduate
teacher.
teachers on contractual basis pursuant to the advertisement dated
This is 27th. I'll just get there.
12th November 2010. 12th November 2010
I'm so grateful.
12th November 2010.
for academic.
So stop.
That is prior to that judgment.
So that such disputes are not raised again and again by unnecessarily, we consider it apposite to notice the public notice issued by the NCTE, which reads as under. Page 49. पूरा quote. There is no gainsaying.
After that judgment, it has been accepted in subsequent advertisement. We have declared that.
No, we are going to impose exemplary cost.
No, my lord, that is subsequent.
Sorry.
Well, in subsequent advertisements.
When you are raising a dispute phase, you should be ready to face consequences.
What my humble submission, after this judgment in subsequent advertisements, we have declared that equivalent. And we have accepted that qualification.
So you should have accepted here also.
Yes, ma'am.
Why are you filing in
this was prior to that judgment. This was, they have prior to
Yes,
that judgment.
Parampur University has the first of even Utkal University. I'll give.
Page 55.
See, the state has luxury to.
No, my lord. Prior to that judgment, these are the advertisements.
Oh, it's a judge.
And after that judgment, we have issued all the advertisement, including that qualification. And now there is no dispute after that judgment.
Mister, the judgment is prospective.
But from 2011 onwards.
Is this your?
No.
We will record that also.
No, my lord. I am not saying that prospecting. Because these advertisements were prior to that.
Mister, therefore, when you file when did you file appeal? In 2023.
Yes, ma'am.
12 years after the judgment was delivered.
Ma'am.
You are making division bench to write a judgment. Which reads as under. Stop. There is no gainsaying that the National Council for Teacher Education is a statutory body on regulating the training in education and in the matters of grant of recognition of a valid grant of recognition of training education certificate / degree. So stop. The notification, the said public notice was issued in August 2009. So stop. Taking into account the said notification dated 31/8/2009, a single bench judge of this court clearly held in case of Suvarn Rekha bracketed Supra that the degree, the qualification of Shiksha Shastri is a B.Ed qualification. So stop. Despite the said notice of the state government accepted the decision in case of Swarn Rekha, and the court has been told that the said decision has been implemented by the state government, and in subsequent notifications and subsequent advertisement, the Shiksha Sastri, degree of Shiksha Sastri obtained from the institution is being treated as valid B.Ed qualification. So stop. Despite that, the state of Odisha has chosen to prefer these appeals, prefer these intra-court appeals, raising the same issue which was set at rest more than a decade ago. So stop. Next. In conclusion, after having considered rival submissions advanced on behalf of the parties, and in view of the facts which are not in dispute and have been noted herein above, we conclude as under: as 1, the qualification of Shiksha Sastri bracketed B.Ed awarded by Rashtriya Sanskrit Sansthan bracketed deemed university Sri Sadasiv Campus Puri bracketed Odisha is a B.Ed qualification as declared by the NCTE in its public notice, in its notice dated 31/8/2009, which is said to have been published in the Gazette of India Part 3, Section 4. Full stop. 2. The appellants are duty bound to proceed accordingly, treating the qualification of the respondents as B.Ed for the purpose of regularization. You call it regularization?
Regularization.
Yes. For the purpose of regularization, which
In terms of that rules, that
That's the resolution.
resolution,
No,
do you have that?
I have not that. There is no dispute that
regularization in terms of resolution, what is that? Do you have that resolution?
There was a recommendation of
It's a
district education officer for regularization that
That
has
is-
been annexed
that
to
is
the
a-
petition.
it's a policy decision of the government in
It's a
respect of
policy
teachers.
That's a policy decision.
Regularization as per the policy decision of the state government.
Well, refer to in page 75, if your lordship wants, your lordship can see that. They have referred to, while recommending, they have referred to certain instructions issued by the government
All right.
whereby they were to be regularized on completion of 7 years.
So, in accordance with the policy decision of the state government.
Right.
First off, the impugned order or orders, there are more than,
Order.
there's only one order.
Here she has noticed for termination due to
Yes,
That we are upholding that.
yes, that has been quashed.
The order of the learned single judge dated so and so requires no interference. Stop. Next. Accordingly, these appeals are allowed.
Dismissed.
Dismissed, yes.
Dismissed.
Sorry, these appeals are dismissed with a cost of rupees 50,000 to be paid to the petitioner within 2 months. So respondent within 2 months.
Cost comes supreme, non-accounting cost of cutting.
Yes.
My lord.
Hey, cost is less.
No, my lord, higher cost, I am saying that my lord has, because cost.
This is too much.
Yours was already.
Can you compensate the predicament of the persons who have been made to litigate?
Yes, ma'am, that we cannot.
Yes,
That-
that cannot be compensated, and this is too much. Some issue which was decided in 2011, you accepted that, and you are challenging in
I
2023.
am not disputing that. I am not because that is the decision and we have accepted it and we have added in subsequent arbiter. There is no dispute about this. And I will not say that but the cost part, that part may consider it.
Cost.
That I'm my
All
solution
right.
to that effect only. Because I have made an endeavor to
Be
make
careful while filing appeals.
my lord. That cost part will also
My lord,
Cost where?
my lord, may I just, my lord, in the connected appeals, the direction was to reinstate them within a period of 2 weeks. There, though the order was passed in the month of September, a contempt petition was filed. Till today, they have not reinstated these petitioners.
All right, they will do it. They may not.
So,
definitely will reinstate.
They may decide to go to jail.
No, my lord, will reinstate. Will reinstate.
Obliged, lordships.
But in terms of these deals are dismissed.
That we are
Cost we have
yes, sorry. Obliged.
accepted your.
Obliged, my lord.
Obliged.
2023, my lord. It's a PIL matter.
Yes, what is your relief?
Order one rule 10 of copy. I filed on IA over copy.
So who has set you up?
Lord, we are the
You have been set up by whom?
we are the villagers.
You are the villagers. So you are in
For
trouble.
the challenge the inaction of the opposite party in discharging their duties by not taking any actions against the illegally dug sand, my lord, from the pond by the means of the JCB and sector without any permission from the government by damaging the trees and affecting the livelihood of the villagers. My lord. A demand notice has been issued against the seven accused, which is in annexure number. Annexure number 6, my lord. A demand notice has been issued by the Tahsildar for paying the amount of 4 lakhs 85,000. My lord. In the annexure 6, the demand notice was issued by the Tahsildar against the 7 accused persons demanding rupees 4,85,267 for the illegal excavation basing on the inquiry report of the RI Kendupada.
In fact, in the meanwhile, when you are making your submissions, we are trying to determine the amount of cost which should be imposed. Because we can easily notice the trend of public interest litigations which are being filed. Most of them are motivated. How much?
My lord.
How much? How much cost you are in a position to pay?
My lord, allowed to
Public interest litigation is not meant for these things.
allowed to withdraw, my lord.
And counsel for the petitioner seeks permission to withdraw this writ application. This application is accordingly dismissed as withdrawn.
Item number 5.
Item 5, Your Lordship. On behalf of Mr. Buddhadev Rautrai, I prefer next week. He's otherwise badly placed today. Otherwise, he would have come before Your Lordship.
This is regarding what?
Which I did violates a particular rule, Your Lordship.
Which rule?
I'm sorry, Your Lordship, I couldn't assist your apprise Your Lordship with regard to that rule because have not prepared with the brief.
What do you want?
My Lordship?
What do you want? Adjournment?
Yes, Your Lordship.
When?
Next week or any day, Your
As
Lordship.
requested on behalf of the petitioner, list this matter on 2 weeks.
Item number 6.
Much obliged.
That's it. In this writ petition, the petitioner is a partnership and he is aggrieved by the whimsical policy decision of the present opposite party, the Indian Oil Corporation, defining the partnership, dissolution of the Partnership Act in a different way altogether, not complying even the provision that lies with the Partnership Act, as well as the clause of the contract agreement that was
You are challenging the advertisement.
advertisement as well as one policy decision of the opposite party, that is Annexure 7,
Page?
page 91.
So you want to participate?
Yes, I am continuing as the stockist of the Indian Oil Corporation
Yes.
and distributing the Servo brand of the lubricant. And Lordship, for a moment, kindly come to clause 39 of the agreement, that is at page 73.
No, what are you challenging?
I am challenging Lordship, kindly come to page 89 first, Annexure 6.
Mr. Das, page 15, part of your prayer.
Lordship.
Prayer number 3, to delete clause 8 to 5 of the renewal policy clause
Lordship.
for the stockists,
Lordship.
as it is contrary to the contract agreement clause and proviso to Indian Partnership Act.
Lordship. For that, I am taking Lordship's kind attention to page 89, Annexure 6. Page 89, Lordship. Lordship, I'll read out. Regarding reconstitution of your farm and other infrastructural requirements. Clause A, as cited in Servo Stockist policy, in case of partnership farm for all partners, normal renewal can be done up to 67 years of age based on meeting renewal criteria. Above 67 years, stockist can be renewed based on meeting renewal criteria for the maximum period such that including renewed period should not cross 70 years. As your age has, one of the partner age has crossed 70 already, you cannot continue anymore as a partner and have to induct a new partner, and reconstitution is to be done. That's it. This very clause, once the one partner attains the age 70 and the partnership act will come for the dissolution.
No, whether this stockist policy, when was this stockist policy framed? In case of partnership for all partners, normal renewal can be done up to 67 years. Where was that?
No, that was not there. Lordship, for that, I am Lordship taking kind attention to page 73.
So when was this introduced? When was this introduced?
In 2022.
2022.
Lordship.
Beg your pardon, Lordship. It's not correct. That's why I'm just, it's my bounden duty to assist my Lord. My Lord, it was introduced in 2020 and it is being revised on different terms after 3 years. And new policy has already been introduced in 2023. This policy, which is being challenged by the petitioner in this case, is of the year 2020. And pursuant to this policy, he has already made an application to introduce a new partner that I have annexed in the counter. You know, so now he cannot return back and challenge the policy of the year 2020 when new policy has already been introduced. And when this agreement of which my friend is relying has already expired since 2020. Because of the COVID situation, this agreement with the new agreement with the petitioner could not be framed. However, he has been advised to frame it because of this policy and the restriction of 70 years.
You have already made an application.
Yes, my Lord. My Lord, yes, ma'am.
Lordship, I have made one application because under duress, I wanted to continue the partnership business with them.
Even you can ask your legal heir to continue as partner.
There is actually no legal heir. One legal heir is there, mine, and he is doing one government job.
Then why do you want to continue with this business? If you don't have any legal heir, you don't have any person who can be who can act in your place, then how long can you continue? You are already 70.
My humble submission is I can work till I attain 90 years. So that does not mean that I'll just want to I'll dissolve my partnership firm.
No, because they have also to run a business.
So because my other partner is there, who is less than 50 years.
Maybe one partner is not enough. Suppose there are 5 partners and 4 of them are 87 years old.
Let's see.
And one is 25. Then because one is 25 years old, therefore he can run the whole show.
Let's see.
But the policy.
Let's see, but they cannot rewrite the Indian Partnership Act.
They are not rewriting in the Partnership Act. They are doing business.
They are doing business, but there is no clause anywhere in their agreement.
Partnership. Yes, you can have your partnership as you wish, your firm.
Yes.
But if you are dealing with the other person, then other person may impose certain conditions that has been imposed.
As he said, your agreement is not extended to
Right.
That is already expired.
Your Lordship.
No,
So new policy has
they did
certain
not recontinue that.
elements. So
Because of this
agreements,
policy.
agreements have to be done in pursuance of new policy, not the earlier policy.
No,
Because under earlier policy, whatever agreement was there, that is already lapsed.
Lordship,
And then-
my humble submission is that policy should not be any contrary to the provision of the act itself. That my humble submission.
Mr. Partnership is for your own purpose, your business. All right, but when you are dealing with some other person for that business, the other person may impose conditions. They are not rewriting Partnership Act. They are saying that, yes, they can have business only if you fulfill this condition. It is not that, why are you making
Then,
this
Lordship,
submission?
I may be given one chance. I'll get one partner and
Okay.
reconstitute my farm.
My lord,
That order may kindly be passed.
That
my lord, he has already submitted that. His daughter has already been nominated.
When counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this application with a liberty to approach the which company?
Indian Oil Corporation Limited, my lord.
Indian Oil Corporation for reconstitution of the partnership in accordance with the new policy of the corporation effective from
29, 2023.
20
5th 9, 2023, new policy.
29/5
25, 9, 2023.
25/9/2020. This application is dismissed as withdrawn with the liberty as sought.
Actually, they may consider my
Full stop. We see no reason why the corporations are not consider the petitioner's case in accordance with its own policy.
My lord.
obliged.
Item number 7.
May I please, Lord? The government of Odisha have decided to acquire the property around Lingaraj temple for development of Ekrama plan. Accordingly, the Commissioner Bhubaneswar Municipal Corporation has submitted additional proposal in respect of a rehabilitation and resettlement policy of Ekrama plan around Lingaraj temple, and government have been pleased to accord approval in additional rehabilitation and resettlement policy. Your Lordship kindly see Annexure 3, that is approval given by the government at page 15, my lord. Page 15. 1-5. May I read, my lord?
Yes.
In inviting reference to letters once on the above subject, I am directed to inform you that government have been pleased to accord in principle approval for addition in the rehabilitation and resettlement policy declared by the government for development.
So what do you want?
They have taken, my lord, I have handed over possession for development of Lingaraj temple for my building and land, but they given 5 lakhs odd compensation instead of, my lord, entire amount 43 lakhs. The Lordship kindly see Annexure 6, my lord. Page 19.
Page
19.
Yes.
In inviting a reference to the subject cited above, I am directed to enclose your copy of a grievance petition dated 9/5/1922 of Sri Ashok Kumar Mahapatra of Harichandni Sai, Old Town, Bhubaneswar, regarding non-payment of a complete compensation amount of rupees 43 lakhs 82,144 under Ekrama plan for development of Lord Lingaraj temple periphery, and request you to ensure that this issue be addressed and action taken thereof may please be furnished to this office. Well, out of 43 lakhs total amount, the BMC, Bhubaneswar Municipal Corporation paid annexer 5 page 18, my lord, to my account. That is 5,51,072.
No, but how do you, who has determined this amount, 48 lakhs,
My lord,
43 lakhs?
they have given one, lordship kindly see, page 23, they have given a calculation. Page 23. Cost of the calculation of entitlement of plot.
Oh, who has calculated?
That authority, my lord, that Bhubaneswar Municipal Corporation. Cost of the land, cost of the structure, and they have calculated total.
Which page?
Page 23, my lord.
23 is your document.
My lord.
His document.
That they have calculated,
Yeah.
given me.
You have calculated, but where is the calculation by them? How do you claim that you are entitled for this amount?
On the basis of my land and cost of the building
And on the cost of the building, then
and recommendation, your lordship kindly see page 19, annexure 6.
you can take a decision honestly. What is he saying? It is the petitioner's case. Notice has been served upon you. Copies.
Copy, sir.
Copy, sir. Copy, sir.
Annexer 8 is pending.
The petitioner claims that his plot and house has been taken over by the Bhubaneswar Municipal Corporation under a Camera plan for development of Lord Lingaraj Temple periphery. First off, according to his estimation, the petitioner is entitled to payment of 43,82,144, whereas only 5,50,000, 51,000
72.
and odd has been paid to him. So, he is said to have approached the Commissioner Bhubaneswar, Commissioner BMC, by making a representation which has not been considered. So, this court, in a proceeding under Article 226 of the Constitution of India, does not have the legally determinable parameters to decide as to what compensation the petitioner would be entitled to. Stop. This writ application is accordingly disposed of with an observation that
Opposite part number 2.
an observation that the petitioner shall be at liberty to pursue his remedy before opposite party number 2 or before any other appropriate forum for establishing his claim. This application stands disposed of accordingly.
Item number 8.
Received also direct on my application, they should dispose of my claim
Pursue that. Pursue.
within certain period so that they will not, my lord. I have already lost my house and only building, my lord.
You have, your house has been taken,
My lord,
your land has been taken,
my lord.
and an amount has been paid.
Only 5 lakhs, my lord.
Only 5 lakh.
Order.
You are saying 38 lakh. Who will say you are entitled to what?
As per rehabilitation policy, my lord.
As per rehabilitation policy, you pursue.
That is annexer 4, my lord. That is annexer 4, my lord, page 16.
BMC shall expeditiously take a decision on the petitioner's representation in that regard.
Item 8.
Your Lordship may write my absence, note my appearance for BNC.
Heard, sir. Yeah.
8, my lords, directed Bhubaneswar Development Authority to serve a copy, my lords. I received that copy. I've also sent it for the information. I pray, my lords, some time, my lords, so that I can give reply to that.
Lord Counsel for the BMC.
But Bhubaneswar Development Authority, my lords.
Bhubaneswar Development
Authority. Bhubaneswar Development Authority seeks adjournment. So, this is matter on 2 weeks.
Item 9.
May I please, your lords? And this is second round contempt proceeding, my lord. Last occasion, my lord, counsel to take instruction.
My lord, I'm appearing for the commission level, container. My lord, I'll file my compliance affidavit. Your lordship, permit, I'll file my compliance affidavit.
Whether the order has been complied with.
Lordship, may I submit one thing, my lord? What happened, my lord? In this particular contempt application, lordship, kindly see the contempt order, original order, retribution order. They have not violated. Rather, my lord, he submitted a petition, fraud document, and ex parte order was passed against the commission. That is my instruction. Lordship, kindly see the instruction I've got. Lordship directed last occasion to detail.
No, what was the order?
Lordship, the order is paragraph 4 is the order. I think repetition order, paragraph 4. अच्छी repetition टा अच्छी नहीं था. In contempt, in the contempt, in contempt page 8, in the contempt petition page 8. We are satisfied that. That's we got that. We are satisfied that BNC is aware of petitioner being a vendor at the vending site, for which he was issued aforesaid document. Full stop. In the circumstances, instead of directing issuance of notice, we make it clear that opposite part number 3 and 4, that is the BNC, in event resort to a taking in action against petitioner, it must be in accordance with law, provided for street vendors, including relocation. My lord, my humble submission is.
So whether action has been taken?
But what happened? I'm something. What happened with regard to relocation and all these things, my lord? Provided trade license and vending identity card. If at all is genuine, then the relocation will arise. In fact, he submitted a fraud document and obtained this ex parte order. So that is why, you can see my instruction. Page paragraph 1 and paragraph 3. That is why.
No, but this is very innocuous order. It could have been passed without hearing you.
Yes.
There is no direction as such except that.
That part annexure 1 of the petition, my lord. He annexed one document.
You are given liberty to decide either this way or that way. You should have passed any order.
That is correct, my lord. But
So,
we inquired the matter.
complaint.
My instruction is like that,
You
lord.
are in contempt.
Let's kindly say my instruction. You inquired the matter. After inquiry, it is found that, my lord, he submitted one fraud document.
So please come to paragraph 4. The first sentence. We are satisfied that BMC is aware of the petitioner being a vendor.
Yes.
On what basis?
So I have a vending license.
Yes, sir.
Huh?
I have,
Vending license, whether that is genuine or not is a question.
no, that is issued by the BMC, my lord, Commissioner
Then
BMC.
they are disputing.
That's a fault of,
Therefore, some opportunity was required to be given to them.
So,
my instruction receipt can see paragraph 1 and 3.
File an affidavit.
Well, I'll file an affidavit.
If we find the route of the National Municipal Corporation. File. Right, taking us time. For problem. The order of the court dated 3/4/2023 in the order dated 3/4/2023 passed in WPC number 3382 of 2023 was admittedly passed without issuance of notice to Bhubaneswar Municipal Corporation. So, in the said order, in paragraph 4 of the said order, relevant portion of paragraph 4 of the said order reads thus following that. We are satisfied that BMC is aware of petitioner being a vendor at the vending site. Or he was issued a aforesaid document, unquote. Stop. Next, learned counsel appearing on behalf of the BMC has submitted that had BMC been given an opportunity from petitioner status as a vendor at the site, at the vending site, would have been clarified. So, stop. We will consider this said aspect for the purpose of initiation of contempt proceeding later. Stop. List this matter on. All right. You can seek review of that order. You can seek review of that order. We are not sitting here in an advisory jurisdiction.
Because he filed a contempt petition, that's why I'm not there.
Yes.
Item number 10.
Date in it.
item 10, item 10 also same.
10.
Here it is find, my lord, virtually the petitioner has used one trade license, which is not a genuine. The trade license rather
The read, Madam,
Item 11.
Madam,
Item 11 in the inter.
Same type of order,
Madam.
same type of order that Mr. Bijadas.
But in the meantime, may I humbly pray that the name of the containers be also corrected because now they are no more working in the beams.
transferred.
And so that the present commissioner is working, then
Someone else should be prosecuted according.
madam, it will be the madam.
It is there, it is duty.
No, it is there. But very annexure 1 itself is a fraud document. Annexure 1, the petition is a fraud document.
But the order.
But item number 11, that batch of cases. Here we are in the process of complying with lordship's order. The secretary has directed the chief engineer to give the details so that financial, because it will some crores. So some time also I've got the letter of the
last order, your lordship's order. They have lodged in the Supreme Court. They have implemented one person's order. These 34 persons are moving here and there. After lodging in Supreme Court, they have implemented after personal appearance of the officer concerned. Before this one.
Your contempt petition was filed in 2024.
My lord, this is the second round of contempt.
Yes, we understand. Something is being done. We are not disposing it off.
My lord.
We are not disposing of the contempt. We shall not dispose of the contempt application.
Obliged.
Till either the order is implemented or they are punished.
Obliged.
So when do you want?
So 4 weeks. In the meantime, we will pay entire amount. Now it's
On an assurance given by the AGA representing the contender, the matter is adjourned to 4 weeks for full compliance of this court order.
Telling which, my lord.
Telling which we will not say.
Already your lordship granted 4 weeks in the last occasion.
All right.
item 12.
All are same.
Item number 12. The lordship, there was a direction by the Honorable Court to dispose of a review petition filed in a OEA, Odisha State Abolition Proceeding of the year 1991. So, because there is a direction in 23 to review was filed in 2022. So, we need some more time because 91 records is not traceable. The Tahsildar has requested my lords to grant some more time.
My lord, lordship has already given 4 weeks time to.
So when was the order passed?
My lord, order was passed on 8th February 2024.
24. 8th March.
8.
No. The order
8/7/2023.
of this court.
My lord, 7/7/2023. 7th July 2023.
By way of last indulgence, the matter is adjourned for 4 weeks further, keeping in mind that for disposal of review filed in 1991, you approached this court in 2023.
My lord. My lord, review petition was filed on 1st February 2022.
But your review was filed in 1991.
The original case is of 1991. Review is filed in 2022. And now they've come up before lordship directing disposal of that review when the original record was consigned long back for more than 30 to 40 years. So we are now trying to retrieve that original record so that we can dispose of the review application.
For weeks as to inform, 4 weeks for the contenders to inform the court as to whether this court's order dated 7/7/2023 is compliant.
Item 13.
May it please your lordship. My lord, this matter notice was earlier issued, but no counter has been filed. And also there is one noting that I am supposed to file the requisites for the purpose of giving notice to opposite party number 4. The other day, in fact, my lords asked that department knows, though no counter has been filed, department knows that money has been deposited. My lord, I am a tender purchaser and I am liable to be taxed at the rate of 4%. Because it is used as scrap and it is unserviceable goods, my lord. That is apparent under Annexure 1, my lord. But the certificate Annexure 5, your lordship may kindly see, it is granted by the Department Commissioner of Commercial Taxes, wherein two things are relevant. That amount has been paid by the dealer and these are the unserviceable goods. This has been taken note of by the department. To some extent, my lord, the identical case, your lordship, my lord, the Honorable High Court said that though we cannot decide it here and directed to raise all certificates, documents there before this, and your lordship kindly appreciate and see. I have given some relevant portion, paragraph 11, the flag mark. I am granting.
You are auction purchaser. You are auction purchaser.
Auction purchaser.
How can you tax the purchaser?
Your lordship, we have not taxed the purchaser. Your lordship may kindly look into the prayer. I am appearing on behalf of the opposite party number 1. There is no grievance against the opposite party number 1. It is an inter dispute. And since 2012, this matter is
Liability is rested on him.
No, your lordship. We have not.
Why has he come?
Your lordship, what
And I have not the arbitration clause. That is an error of record.
Let me-
Though I have said that is their clause, but this is in the nature of that. With all respect, may I just submit? It has been held that Honorable High Court may not enter into the disputed questions of fact. But the fact that payment has been made, accepted by them, is a telltale in view of their certificate under Annexure 5. Two things are relevant. That the goods are having mentioned that the goods are unserviceable scrap. How can they charge? And I have made payment through my dealer. And I am now, with all respect, claiming my benefit through my dealer. My lord, with all respect, my lord, Government of India undertaking was given the us the in tender, my lord. So ultimately, my lord,
Respond to my lord's query first.
your lordship may kindly look into the prayer at page 6. It is therefore free, calling upon the opposite party to show cause as to why excess tax amount collected by the opposite party number 2 shall not be held illegal, shall not be refunded to the petitioner, and if the opposite party fail, make the said rule absolute by issuing appropriate orders. Now, your lordship may kindly look into Annexure 1. Annexure 1 is an auction sale notice. Down the buyer, the seller here is the MSTC, and the purchaser is the buyer. And the buyer has argued, the purchaser is the petitioner. The petitioner has agreed to pay 12 points, but this is a contract in between the buyer and seller. So as per the contract, as per the auction sale notice, the seller has collected 12.5% tax and deposited into the government treasury before me, the department. Your lordship, there it is end. Subsequently, the petitioner, the seller, the purchaser, subsequently the purchaser has disputed with the seller that it should not be taxed at the rate of 12.5%. Since it is a scrap, it has to be taxed at the rate of 4%. So since the seller is a dealer before opposite party number 1 before me, so it is to be assessed, the seller is to be assessed. Here, there is no relation in between the purchaser, the petitioner, and me, the opposite party number 1, the department. Here, the seller has collected the tax and deposited. So, it is the inter se dispute, contract dispute in between the seller and the purchaser. And accordingly, your lordship, arbitration has been invoked. Your lordship may kindly.
Invoke whatever.
Yes, most obliged. And the same situation.
Redressal office, grievances, petition stands. Business has withdrawn with the liberty as now.
Disposed of my liberty to.
Stands disposed of in the.
Yes, sir. Most obliged.
Gratefully.
Item 14.
But in this case, several writ petitions were disposed of by this honorable court with a direction that the petitioner will file appeal before the Board of Revenue and that will be disposed of within 6 months. I have already brought all the appeal case records. What has happened after this order, the respondents were not, the appeal was filed, the parties were heard, and the case was finally within the time period, it was posted for orders. But at that time, parties asked for giving certain instructions for which it was deferred, and in the meantime, that 6 months time was expired. So we have filed the extension of time. My instruction is that your lordship may extend it to the till the date of March 30, this 31st March, we will pass the final orders in all the appeals. Today, one appeal is listed. All the appeals will be disposed of by the end of March 2024. Because it is already matured for orders and judgment.
How many such cases are there?
There are, I am just giving. 8, 4, 5, 6, 7, 8, 9. 9 writ petitioners were there, and accordingly 9 appeals, 9 appeals, 9 excise appeals.
So 9 writ petitioners are.
9 writ petitions were disposed of by a common order by this honorable court, directing them to file appeal. They filed 9 excise appeals.
You are representing home government.
I am the state appel, the petitioner in this IA.
88. And 80, Mr. Dev, until and he submits that in the light of this court's order dated 24/11/2023, appeals have been filed by the petitioners.
Writ petitioners.
Here. These are the writ petitioners.
Yes.
By the petitioners. Before. Whom?
Court of Member Board of Revenue.
For the court of member board of revenue.
Odisha, Cuttack.
Odisha, stop. Odisha, Cuttack, stop. Next. He submits that the appeals and that all such appeals shall be decided by the end of March.
March 2020.
Accordingly, the time allowed by this court by an order dated 24/11/2022 is hereby extended to March
31st March.
31/2024.
Yes, obliged.
Item number 15. My lord, pardon, my lord. May I pray, my lord, this batch of cases, 3 writ appeals, may kindly be taken up 1 week.
Well, that will,
My lord,
that we will not do. We cannot keep them.
no, your lordship may fix any day of your, as per your lordship's convenience, your lordship fix any day.
Matter about.
A common order passed by the Lord single judge is under challenge in all these 3 cases, where a recruitment, the selection process in a recruitment is under challenge. What has happened, my lord? In this particular case, if the person securing much less marks has under your category were appointed, whereas a person belonging to reserve category candidate, despite securing much higher mark than the your category candidate, has been taken to the reserve category list and accordingly was denied with appointment.
When do you want?
My lord, any day as per your lordship's convenience.
After how many appeals?
But 3 appeals.
Appellants, the appeal on 2 weeks.
Item 16.
In item 16, the affidavit as desired by your lordships as per the High Court rules has been filed, supplementary affidavit. Now, my lords, there is one more application which is I'll be filing in course of the day, delay condonation limitation petition. In course of is ready, my lords. So can your lordship grant me the liberty to file it in course of the day, my lords? I'll.
Yeah. The application for contempt will not be late. It's in the process of being filed.
Yes, today.
And shall be filed in course of it.
Right.
Let it be done. Just this matter on
Next week.
2 weeks.
That's next week.
Okay.
Obliged. Great.
Item 17.
May please, your lords, kindly permit me to withdraw.
Item 18.
I beg to submit, my lord, both reads, both way application, my lord. Some of the rehabilitation scheme, my lord, that some of the documents, my lord, filed in the court below has not been taken into consideration. Thereby, my lord, it will be appropriate that if I withdraw it with liberty to file a review petition, because that documents with the file, but is overruled with the liberty to file a review petition, my lord, both the cases.
Appellant seeks permission to withdraw this appeal. Clerk would appeal with the liberty to review of the order which is under appeal.
Both cases, 2 cases coming on, my lord. 3-1 and 2-1 and 3-1-19. Wait.
These appeals are accordingly dismissed and withdrawn with the liberty as
Item 19.
Hello, this case relates to job contract employees now, where the Honorable Court has directed for to treat the entire job contract period as towards pensionary.
Prior to that, sorry for interruption, identical matter.
You have the amendment in the meantime. Yes, ma'am. And madam, I am giving the
Identical matter, that is the Honorable Apex Court has stated the order of the division bench. So that is futile exercise. So my submission, let it lie over. Thereafter you will assimilate.
I was passing on those orders. In a batch it was taken, my lord will first find the first order, para 7. Thereafter, other orders. And also I have given a judgment of this Honorable Court.
The dependency of same matter is pending.
Manner, similar order, similar matter. Same issue.
How many cases are there? How many appeals? Only one.
Before on the honorable
Only one,
Apex-
here is only one.
before honorable Apex Court, more than 100 cases are there.
This is appeal on, when do you want? 8 weeks?
My lord, that depend upon,
Huh?
that is depend upon the apex courts.
Yes, after 8 weeks, we will again
My lord.
adjourn the matter for 8
Two months after your lordship, I think.
8 weeks.
My lord,
Because we cannot adjourn it for a year.
my lord.
8 weeks. As jointly requested. We are not mentioning it.
My lord.
My lord, those orders may be, my lord may kindly be part of record. I have given.
No, we are not referring to that. We just adjourn.
Item number 20.
May I please your lordship, sir? My lords, lease involved in this writ application relating to 2 acres and 564 decimals of valuable land of a charitable, religious charitable endowment, my lords, namely Siddheshwar. My lords, as per the Hindu Religious Endowment Act, under section 19 of the, any property is to be sold, under section 19, there must be a permission. And in this case, the permission was granted and it was carried in an appeal. There was initially the price was fixed for 20 lakhs, 25 lakhs, and thereafter it was reduced to 15 lakhs. And your lordships, by annexure 2, it was put to auction. Plus the latter part of the order by the Honorable Minister of the Appellate Authority, they directed that it should be done. Initially, it was done by public auction. Thereafter, the negotiation was also added. For the petitioner,
Why have you come to this one?
because there was an order, Justice Sarangi rescued.
No. Why? This is of 1999.
My lords.
The writ petition was filed in 1999. And it was your prayer that the
auction and the because this is
you could have filed a suit.
But this honorable court passed an interim order initially. Thereafter, after hearing all the parties, wanted to hear this matter and directed that the matter be any action taken pursuant to the auction shall be subject to result of the writ petition. That is how, milords, the writ petition is pending. It's a public charitable endowment property. Your lordship knows that Supreme Court in different judgments, it must be jealously protected. It must be protected for the land. I will show your lordships that how the basic factor, milords, the parties 4, 5, and 6 of this writ petition. 4 is the managing trustee, who is the mafadar of this property. 5 is his brother-in-law, who has been stated to have been given a power of attorney to manage the institution and conduct the auction. And 6, who is the auction purchaser, is the brother of opposite party number 4. Plus, this is the kind of auction.
And property belongs to whom?
Siddheshwar Mahadev. It's a religious endowment property. I was the petitioner. It was thoroughly had and all the counters and as well filed. The petitioner wanted to participate in the tender. Means that was a sale process. My application was not received. Then
finding no other way, saying that the hereditary trustee opposite party number 4 is in Delhi. Then Millers, I finding no other way out, I went to a additional assistant environment commissioner, who is the person whose presence the auction has to held, and his decision is to final according to. Then I went there before the time. Decided I am not able to give my offer. Then Millers, he received the application, is my tender, and asked me to appear on the date of negotiation. And on the date of negotiation, when I went, then
that you are against the decision to auction sale the property, or you have given that you were not allowed to participate.
Plus, because as a participant, I wanted to participate in the tender.
If you participated, then you cannot question the decision to auction sale.
Now, I am not challenging. I want.
This is what you are saying.
No, Millers. Millers, my submission, because I have sought for to pause the auction and to go for a fresh tender. That is what my prayer. And to allow me to participate in the tender.
You created an impression that the auction itself, the process of auction itself was illegal.
Millers.
It ought not to have been done.
No, Millers, sir.
And now you are saying that you had also participated.
No, I wanted to, what is the lease about? Because the lease is with relaxed property. I wanted to also participate, and it was a clandestine altogether, without a clandestine sale. So I could go when I put forth my.
Why are you making this submission of protection of property of public religion?
Because Millers, if my application would have been allowed, I would have been taken in a much higher price, other participated, and it would be in best interest of the endowment Millers. That is what my cost. That they prevented me, specific case Millers, they prevented me to participate in the tender. There was, Millers, let me show your lordships 2-3 Millers. Hindu religious center.
Section 73, 68 page.
There is no bar to see.
This is 73, your lordship.
73 is something else.
Millers, this is bar of suits, your lordships,
That is confined to in respect of administration of a religious institution or in respect of any other matter or dispute for determining or deciding which provision is made in this act shall be instituted in the court of law.
Here, Millets, the proceeding was taken up under section 19. Millets, the permission was granted. Within that scope of that provision, Millets, the property was put to auction. And Millets, by submissions before the lordships, the matter has been thoroughly, Millets, examined by this honorable court, and pleadings is over, and it was placed for hearing of the matter. And your lordships, that was an order also in 99 that any action taken, first initially there was a stay. After hearing, the court said that any action taken to pursuant to the auction shall be subject to result of the writ petition. With that note, Millets, the entire process has proceeded. Now your lordships, I placed your lordship for examination.
We are deciding dispute between you and the person who is the auction purchaser or
No, Millets,
it is primarily a dispute between you and the auction purchaser.
No, Millets, me and the heritage trustee or the organization who was the religious endowment who was doing the auction.
Your submission is to be accepted. The auction sale ought to have been made in your favor.
No, how could Millets, negotiation. Once Millets participate, I am allowed to participate, then the process of negotiation, I could have been a participant. Yeah, and who will be winner? Whether he will be the winner or I will be the winner, at what price it will be.
Had you been the winner, you would not have approached this court.
Millets, if the best price.
So you are interested, you have an interest in your own, your own interest.
Millets, I participated, Millets, my right to participate is my fundamental right, your lordships. And I was debarred.
Sir, please, if you come to
It is evident from the subsequent order dated 6/8/99.
But they question that how I brought the draft, more particularly when the judicial officer, additional assistant commissioner has received the draft.
Mr. The whatever plea which you are taking here, you could have taken there before the civil court.
The lease was filed and it was pending your lordships, and the pleadings was over.
It was pending. It is clear observation made by this court in 1999.
Ballots. And
so
saying that
have taken a hint from that.
Lords, when the matter is to be heard on merit, because that was not a stage where lordships matter was heard on. They question that if at all, if we lose, if the petitioner succeeds, then we will go somewhere. But if we Your lordship knows the three parameters, then what will happen if the writ petition doesn't succeed? With that parameter, Millards, that order was passed saying because they raised some questions which are altogether relevant according to me.
We are not satisfied.
Millards, only thing in Millards, there are this property since belongs to religious endowment, and Millards, the fundamental.
You have no interest in that religious endowment. You have your personal interest.
Millards, that is in respect of a tender, your lordships. Millards,
Don't bring this court into such controversies. The High Court is not particularly exercising writ jurisdiction.
My lords.
Had it been a civil court, the matter would have been different.
But Millards, can 456, can the matter be settled with 6 when he is brother? Well, can the lease of the property which belongs to endowment and you are in caretaker of that property as a will sold the property through your brother-in-law to your brother?
Counsel, please understand that we are not in the witness box.
My lords.
For you to put questions to the court.
My lords. I am asking a question to myself.
This is not the way. Can and this and that.
That's my submissions before your lordship. I'm extremely sorry.
As if we are in the witness box and you are putting questions.
No. So I was asking a question to myself. Can the transaction between the 4, 5 and 6?
Sorry, the court has earlier the court has taken note of everything 6, 8, 1999. And please try to behave yourself. Don't put questions to the court.
No, sir. I'm extremely sorry. I was putting a question to myself, my lordships.
We are not inclined. This writ petition was filed in dictated judgment order in the next second after recess.
I don't put the order.
Is there any matter fixed at 2?
Yes. Yes. There's a matter that reservation matter is fixed.
All right, we will hear that matter because it will take time. We will dictate the order.
Yes.
The next. Yes.
Matter fixed for 2 PM, item 41.
I thought your lordship will pass the order thereafter it will hear.
No, because it will take time and if
No, no, it's
Item number 41.
Your lordship, I have prepared notes and submission, your lordship. Additionally, your lordship, one IA is there. Sorry. Flag F, your lordship.
yes.
My lord. Lordship, may I take a lordship to the notes and submission which I have yesterday, your lordship? Sorry.
Yes.
May I place it?
Yes. Yes.
Matters. Your lordship, I have stated the brief facts of the case in my notes, your lordship. May I take your lordship to my notes, your lordship? Read petitioners who are now respondents numbers 4 to 11 in this appeal, your lordship, and the opposite part numbers 4 to 34 in the writ petition, who are now appellant numbers 1 to 5 and pro forma respondents 12 to 37. They were initially appointed as forest rangers, your lordship.
Yes.
Your lordship, here in this case, your lordship, there are 3 posts which are coming into consideration, your lordship. The initial post is forest ranger. Thereafter, the promotion has been to the assistant conservator of forest. And now the case is for the deputy conservator of forest. That is the further promotional post, your lordship. So 3 posts are in here, involved here, your lordship. Initially, your lordship, from 2014 to 2017, opposite party numbers 4 to 34, who are appellate numbers 1 to 5 and pro forma 12 to 37, they got promotion to the post of assistant conservator of forest in the grade of this Orissa Forest Service Group A junior branch, your lordship. This is a junior branch, and the deputy conservator of forest is the senior branch, your lordship. 2018, your lordship, that means after this, these opposite parties were promoted as a CF. 2018, the writ petitioners who are respondent numbers 4 to 11, they got promotion to the post of SCF, Assistant Conservator of Forest. In 2022, Your Lordship, a gradation list as on 01/09/2022 that was published, showing the writ petitioners as senior to the opposite party numbers 14 to 34. It being annexed 2 to the page 46 of the writ petition. Now I have also filed this particular document as enclosure 1, Your Lordship, to my notes, Your Lordship.
No, they were granted promotion in 2014-17.
Opposite parties and the respondents, and the writ petitioners, they got in 2018, Your Lordship. They got later.
You are the writ petitioner.
I am for the respondents 1 to the appellants 1 to 5, respondents, Your Lordship, that
you were the writ petitioner.
we were promoted earlier, Your Lordship.
No, you are not the writ petitioners.
No. I was the respondent. Opposite parties.
You were opposite parties in the writ petition.
Yeah. Writ petitioners are now represented by my learned friend Mr. Mishra. In 2022, Your Lordship, the gradation list was published as on 1/9/2022, Your Lordship, which showed the writ petitioners as senior to the opposite parties, 14 to 34, as SCF, Your Lordship, Assistant Conservator of Forest. That followed with the catch-up rule that was published, Your Lordship. Because these are admitted facts, so there is no dispute over these things, Your Lordship. And that continued so far, that has continued so far, Your Lordship. Now, Your Lordship, 3/3/2023, Your Lordship. There was a communication by the government, Your Lordship, whereby disciplinary proceeding reports of opposite party numbers 4 to 34, where through the writ petition were called for to consider their case for promotion to the next higher grade, that is Deputy Conservator of Forest, DCF, Your Lordship. That was in 3/3/2023, which I have annexed as enclosure 2, Your Lordship. And in that communication, Your Lordship, the writ petitioner's name did not find place, Your Lordship. And that was the cause of action for them to file the writ petition, Your Lordship. Because my humble submission is that, Your Lordship, by that time, they were not eligible as per the rules under which these promotions were going to take place, Your Lordship. And that rule also I have placed at enclosure 3, Your Lordship, to this note, which is also there in the part of the pleadings, annexure 4 to the writ petition, but it is now enclosure 3, Your Lordship.
What is that rule?
Rule is that, Your Lordship, the Odisha Forest Service Group A Senior Method of Recruitment and Condition of Service Rules 2015. Your Lordship may kindly have a glance at that rule, Your Lordship, which is Your Lordship finds at page. Yes. 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 Absolutely. Page 19 of my notes, Your Lordship. Annex enclosure 3, Your Lordship. Which was also earlier in annexure 4 to the writ petition.
Page 19 of what?
Of my note today, which I have submitted
Note.
today.
All right.
Sorry.
Yes.
Your Lordship may come directly to page 20, the next page, which part 2 says method of recruitment, Your Lordship. Rule 4 says methods of recruitment. Subject to other provisions made in these rules, the recruitment to the post in the service shall be made by promotion in accordance with these rules, Your Lordship. Then your lordship 5, eligibility criteria. Your lordship may kindly note the word eligibility. No officer shall be eligible for promotion to the post in Group A, senior branch of the service, unless he or she has completed 5 years of continuous service in the grade of Odisha Forest Service Group A, junior branch, as on the first day of January of the year in which the board meets. Otherwise, in other words, it means that if you have not completed 5 years as on 1/1 of the particular year in which the DPC will be sitting, you will not be found eligible. This is the long and short of it, Your Lordship. Now, as I have just submitted before, just a little before, in 2018, the writ petitioners got promoted as Assistant Conservator of Forest, which is in the rank of that OFS Group A junior branch, Your Lordship. So they were not completing 5 years as on 1/1/23. Undisputedly, that is the case between the parties, Your Lordship. Now, after that, Your Lordship, this was challenged, Your Lordship, in the writ petition, that is 7388 of 2023, and the prayer of the writ petitioners, which I have quoted, they are also in my note, Your Lordship, page 2. They say, their prayer was to quash the communication dated 3/3/2023, issued by OP number 1 under answer 1. So far as it relates to the promotional exercise of 4 to 34, as the same is contrary to Section 4 of the ORV Act and the judgment of the Honorable Supreme Court in case of Prabhakar Malik, the State of Orissa, 2020-15 SCC, and direct the OP number 3 not to promote 4 to 34 by resorting to reservations in promotions without recasting the gradation list under Annexure 2, keeping in mind the judgment of the Honorable Supreme Court in the cases of so and so, so and so, so and so, and direct the opposite party number 10 to issue a fresh communication for promotion to the post of Deputy Conservator of Forest OFS Group A, without considering the aspect of reservation in promotion for such posts, and by considering the petitioners as senior to OP numbers 4 to 34. These are the 3 basic prayers, Your Lordship. Your Lordship, what I have understood, Your Lordship, the main prayer, the main thrust before the Honorable Single Judge was that this communication under 3/3/2023 has been issued in the guise of giving promotion to the reserve candidates because they are sought to be reserved categories again. But in fact, that is not, Your Lordship. And Your Lordship, I will take Your Lordship to Annexure 2, the enclosure 2, Your Lordship. 3/3/23. Yes. Your Lordship, at page 16 of my note, Your Lordship, which is enclosure 2, Your Lordship.
Yes.
Here, my lords, many of the names which found place in that, actually there are 31 names, Your Lordship finds. 31 names. Out of 31, Your Lordship, besides this opposite party numbers 4 to 34, there are other names who are belonging to the unreserved category. There has been general candidates, Your Lordship. And this communication was done solely keeping in view the eligibility clause, Your Lordship. That Rule 5, Your Lordship, which I'm just...
Seniority.
Yes. Eligibility, 5 years of continuous service. They must have in the lower branch. Now, Your Lordship, and they also find that counter was filed by the state and the other opposite parties, and which showed that the petitioners, the writ petitioners, were not coming within the zone of consideration because they lacked the eligibility criteria. That is the consistent case of the state as also the other opposite parties. Then they had not completed 5 years of service as on 1/1/2023, and principles of reservation have not been applied for promotion to the post of DCF. The deputy
plea was taken.
This was the consistent plea of the taken. And the government also came out with the counter in clear terms in these lines, Your Lordship. Then, Your Lordship, on 15/3/2023, one interim order was passed in the writ petition that DPC can be held, but the same shall be put in a sealed cover, Your Lordship. And accordingly, DPC was conducted and put in a sealed cover also thereafter, Your Lordship. Then 12/5/2023, and 4/9/2023, there are two further interim orders, Your Lordship, where opposite party numbers 4 to 13 in the writ petition, they being admittedly senior to the writ petitioners, interim order was vacated against them only, Your Lordship. And their cases were considered, their seal covers were directed to be opened and appointments to be given, Your Lordship. And accordingly, Your Lordship, three persons have got appointment as DCF also. And that has been protected by the Honorable Single Judge in the judgment also, which is now impugned here, Your Lordship. And the 10/11/23, Your Lordship, the judgment has been pronounced holding that the impugned communication under Annexure 1, being a product of arbitrary exercise of power, cannot be sustained in the eye of law. This is the wording which is given, Your Lordship. Inasmuch as it indirectly seeks to grant the benefit of reservation in the promotional post to the juniors, like the private opposite parties, ignoring the inherent seniority of the writ petitioners as reflected in the gradation list. In one line, I have summed up the entire judgment directive in this line, Your Lordship. May I take, Your Lordship, to the judgment, impugned judgment, certain paragraphs, Your Lordship. And well, Your Lordship, in the appeal, Your Lordship, on 14/12/2023, Your Lordships have been pleased to issue notice in the appeal, Your Lordship. And as an interim, there have been stay of operation of the judgment dated 10/11/2023, Your Lordship. And on the last occasion, Your Lordship, I'm sorry I could not be present to place our submissions, Your Lordship, on the last occasion, Your Lordship. Your Lordships have passed the order on 29/2. Your Lordship may kindly see that order dated 29/2/2024.
Yeah.
Your Lordship gets. There was an IA filed by the state government, Your Lordship. This is the IA filed by the state government to cause vacation of the stay and to permit them to go ahead with the communication, which is at enclosure 1, Your Lordship. That is 3/3/2023. So that they are in need of the promotional post being filled up. So they needed permission to go ahead with the DPC proceeding, which was held after 3/3/2023. That was the prayer, Your Lordship. And Your Lordship has allowed, Your Lordship. In the meanwhile, though the DPC, in terms of para 21 of the judgment, dated 10/11/2023, passed by the learned single judge in WPC number so-and-so, may proceed with the matter for promotion. High post shall be kept reserved so as to protect the interest of the appellants, Your Lordship. Your Lordship has passed this order.
Which order?
29/2/2024, Your Lordship. Order number 3 on that date. In IA, Your Lordship, IA 333.
Yes.
My lords, I may be permitted to take Your Lordship to the subsequent development which has happened, for which I am also before Your Lordship today. This is, Your Lordship. Your Lordship may kindly find IA number 863 of 2024, in which I have also annexed a letter dated 2/3/2024, which is pursuant to Your Lordship's order, which has been issued by the government, Your Lordship. And there, what has happened, Your Lordship? The persons who had got promoted as ACF, that is the lower feeder cadre, Your Lordship, ACF, in 2023, they have been enlisted, Your Lordship. Not only 18, but after 18, all 184 candidates, Your Lordship. And if I am not wrong, I was hearing that there were about 35 to 40 vacancies which are there. But 184, and this again, which doesn't cater to the eligibility criteria. That has been completely violated. So I will just pray for Your Lordship's kind intervention, whether this will be permitted, because whether this will be granted as a legitimate permission which has been granted by Your Honor, your court, by the order dated 29/2/2024, Your Lordship. And Your Lordship, section, Your Lordship sees that in that particular letter, which is at annexer 3 to my that IA.
Your short submission is that a process of consideration for promotion to the post of DCF senior branch was undertaken.
Yes.
It is also your case that there was no stipulation that any reservation shall be granted in the matter of promotion.
Yes, sir.
The writ petitioners were not within the zone of consideration. They were not kept within the zone of consideration because of the
Lack of eligibility criteria.
ineligibility in terms of the rule.
Rule 5. Correct.
They approached this court with a grievance that the state is implementing reservation policy in the matter of promotion, contrary to the decisions of Supreme Court in
Yes.
case of Nagraj or.
Yes, all followed the opposite.
All right. So this was their case.
Yes.
So what is the finding of the learned single judge?
That I am taking to Your Lordship. That I am taking to Your Lordship. Madam. Yes. I need. The Lordship may kindly here is page 51, Your Lordship, of the writ appeal, Your Lordship. Writ appeal, Your Lordship. I'm sorry. My Lordship, I'm sorry, Your Lordship. That was our submission, Your Lordship. Yeah, there is the submission of my learned friend, Your Lordship, in para 15, Your Lordship. Para 16, Your Lordship, I kindly have a look at page 52. Inter alia, I'm sorry to say, Your Lordship, inter alia, what the petitioners wanted to say before the Honorable Single Judge that once having been granted prior to promotion as a reserve candidate, they should not be further promoted to the reserve as a reserve candidate again, so that the seniority rule which has been fixed also, seniority list, that will go all considered, Your Lordship. That was the entire case of the writ petitioners, Your Lordship. And here they say in page 52, the Honorable Single
How
Judge,
is the issue of reservation emerged in the
that is exactly because that was their allegation, that once they have been promoted prior to us, but by the seniority list being held as the catch-up rule, Your Lordship, being applied, Your Lordship, the matter has been settled, Your Lordship. That we become the general candidates, become senior to the reserve candidates, Your Lordship. And having done that, Your Lordship, the government cannot again make a promotion to them or offer a promotion to them without considering our case. That is the entire thing in the entire background of the case, Your Lordship. And Your Lordship, inter alia, they also challenge that how they have got promotion as ACF, Your Lordship. These opposite parties were the ACF. That was also challenged in between, Your Lordship, in the writ petition. And Your Lordship, this Honorable Single Judge says at page 52, the para 15.
Is this their case?
My Lord?
That at the stage of initial entry in the rank of forest ranger, they were senior.
They were earlier.
Yes. All right. So if they were seniors,
yes,
then how could they become juniors?
No, because the promotion was done to the opposite parties in 2014, 15, 16, 17, like that.
Why their cases were not considered?
Why not?
Why their cases were not considered?
That at that point of time, the seniority list as in proposed in 2022, that was not there.
How could you become senior? That is the question.
That's right. That of course, that I have not exercised into that out there. But the fact remains, and the administrative case is that
therefore, we don't know. We have not gone.
And that was not challenged, Your Lordship. That has not been challenged. That promotion has not been challenged by them.
So whether policy of reservation was applied,
yes,
at the stage of promotion from the post of ranger to ACF,
yes,
it was applied.
Yes.
That was incorrect.
Yes, yes, of course, whatever has happened and happens because I cannot go into that aspect also. But that matter was set right by correction in the seniority list in 2022, Your Lordship. And they have not challenged, admittedly, the promotions given to the opposite parties as reserve candidates. They have never challenged, Your Lordship. That was not under the subject of challenge at any point of time.
No, all right.
Yes.
So therefore, these petitioners writ petitioners are such persons who could not get promotion to the rank of ACF because of the reservation policy applied.
Yes. Yes.
All right.
Yes. Yes. Yes.
For promotion to ACF junior branch.
Junior branch. Yes.
So in senior branch, the state did not apply the reservation policy.
No, that didn't apply.
But in junior branch, they had applied. And this was their grievance.
That's it.
So had that policy been not applied, the reservation policy, they would have been promoted prior to that 5 years.
Yes.
They would have been eligible. That is the question.
Might.
That is the dispute.
Might.
All right.
Might be. Your Lordship, what the under single judge says, Lordship, in page 52, Your Lordship finds. I'm taking Your Lordship to the middle of that page, Your Lordship, where the final gradation list prepared subsequently after application of the catch-up principle to restore the seniority of the petitioners was never been challenged. To such extent, therefore, this court is inclined to accept the argument advanced on behalf of the private parties that it is too late in the day to raise any grievance as regards the legality and validity of promotions granted to the rank of SCF. That is the SCF junior branch, Your Lordship, who got prior promotion than the writ petitioners, Your Lordship. Then Your Lordship comes to para 16, Your Lordship. This court would now focus its attention as to the legality of the impugned communication. As already stated, according to the petitioners, the benefit of restoration of seniority that they received by application of the catch-up principle is sought to be nullified by the impugned communication. On the other hand, according to the opposite parties, the seniority of the petitioners having already been restored, but they being ineligible for further promotion cannot raise any grievance. So, Your Lordship, two words Your Lordship may kindly note. One is the seniority, the other one is the eligibility, Your Lordship. These are the 2 points or 2 words which play a vital role in this entire case, Your Lordship. Now the question is whether the principle of reservation is sought to be extended by the authorities in the proposed promotion. Your Lordship asked me that question also. This is the case. The impugned communication under Annexure 1 on the face of it does not say so. The State Council as well as the Land Steering Council appearing for the private opposite parties have emphatically argued that the principle of reservation is not sought to be extended for promotion to the rank of DCF. Rather, the promotion is sought to be made by invoking the eligibility clause. This being the fact situation, the decision cited by Sri G. Mishra, my land friend, Your Lordship, in relation to the applicability or otherwise of Article 16(4)(a) of the Constitution would not be relevant at all. To amplify the need of obtaining quantifiable data by the state regarding inadequacy of representation of the reserved category persons in public service being sine qua non to apply the principles of promotion with consequential seniority to them as envisaged in M. Nagaraj are rendered redundant. Then Your Lordship, Rule 5 is quoted. I have taken Your Lordship, so I need not repeat it again. Thus, the rule provides that an officer shall not be eligible for promotion to the post in senior branch unless he has completed 5 years of continuous service in the junior branch as on the first day of January of the year in which the board meets. The proposed promotional exercise being scheduled to be held in the current year, that is 2023, the last year, Your Lordship. The relevant date for consideration of eligibility would be 1st January 2023. Admittedly, as on that date, the private opposite parties had completed 5 years of continuous service, whereas the petitioners had not. Thus, prima facie, they are not eligible for being considered for promotion to the senior branch. But then, if only the eligibility clause is harped upon and the proposed promotions are effected, it would entail a situation where the private opposite parties, who by virtue of the principle of reservation had been promoted to the junior branch earlier than the petitioners, that is general category candidates, would definitely steal a march over the petitioners. This is the since on the face of it and on record, the principle of reservation would not be applied in case of promotion to the post of DCF, the catch-up principle would also not be applicable if and when the petitioners are promoted to the senior branch. In other words, this would lead to a situation where the inherent seniority of the petitioners, restored by application of the catch-up principle in the year 2022, would be lost forever. It would be back to square one. If to further elaborate, the private opposite parties who are inherently junior to the petitioners but had marched ahead of them by virtue of the principle of reservation would become seniors to them for all times to come. According to the considered view of this court, this would be entirely contrary to the principle of equality enshrined under Articles 14 and 16(1) of the Constitution of India. Thus, as between the question of seniority and the eligibility criteria, this court is of the view that the former shall take precedence, the former means seniority.
So whether the DPC meeting has been held or not?
Yes, there has been held, Your Lordship.
When?
In 2023, the DPC has been held, Your Lordship. 2023, 20th March 2023. And the results have been out in respect of the 3 persons who had got promoted, Your Lordship. In pursuant to that, Your Lordship. Now that communication has now been quashed. This is the confusion, total confusion. There, Your Lordship, if I am not wrong, 1 persons. 12, 4 to 13, 11. 11 persons where their results have been out, Your Lordship. Because 3 got promotion, the rest could not get promotion because they had the DP proceedings pending, Your Lordship. Their cases could not be committed.
And those 3 persons are?
Those promotions which were granted by virtue of orders, those have been saved.
That's why I'm pointing out to the court.
No. Our question is,
ask me a question here.
Our question is something else.
Yes.
Whether the 3 persons who have been granted promotion were junior to the writ petitioner.
No, they are senior, Your Lordship.
At the initial stage of entry into the forest service as forest ranger.
They have been senior. They were
our concession, the interim orders were passed to promote them. And the impugned judgment also protects that.
Yes.
We considered that since they are our seniors, kindly take them.
That I have already said, Your Lordship. That I was going to clarify because 11 persons have been named, consideration of names of 11 persons were considered, and by virtue of the interim order, 3 have been promoted, Your Lordship. In the meantime, who have been protected, I will take, Your Lordship, to the last portion of the judgment.
No, but the DPC of 2023 is over.
Over. In March 2023.
So now, the DPC will be held in 2024. So for 2024 DPC, they are eligible.
Who, my lords?
These
yes. No.
So what is the dispute then?
No, dispute is that, Your Lordship, now what the government is doing, they are totally quashing, they are brushing aside the 23 DPC, Your Lordship. They have now published, they have come up with a list.
For every DPC, they will have to come out with a list.
Yes. That's
therefore, they are coming out with a fresh list for 2024 DPC.
My lordship, had they considered 24 also, we have no quarrel also. We don't stand on the way, Your Lordship.
What problem do we have?
Well, because our names again come up here, and where our names have been shown junior to them, Your Lordship.
You are junior.
Yes. No, I was, but can it be again considered, Your Lordship? That is the question.
Can it be?
Can it be again reconsidered in a DPC, Your Lordship, where the DPC has been held for us, DPC has been held?
No.
Not for what I am submitting, Your Lordship.
No, see, Mr. Whenever the DPC is held,
yes,
they are obliged to consider all the names who do have the qualification.
Yes.
So if you figure in that zone of consideration, your name shall be considered. They are bound to consider. Only because DPC was held and in that DPC your name was not considered, or
no. I was considered. Yes. I was considered. I was also found, if I am not wrong, because I will be found suitable, Your Lordship.
All right.
Subject to the departmental proceedings, if any.
So they will again consider your case.
No. What I am submitting here now, what has happened? There they are now considering the names of 223 who have been appointed.
Who
are also. To 2023 who have been promoted as SCF, their names considered. They don't find eligible. 5 years they don't complete. Your Lordship, if we take into account Rule 5, the only eligibility criteria, if they take at the first instance, Your Lordship, the writ petitions shall definitely come in.
2 aspects. We are just thinking of the safest course.
Yes.
Without entering into that reservation issue.
Yes.
The safest course would be that let there be a DPC for 2024.
Yes.
You are admittedly junior to the writ petitioners. For certain reasons, you had you had been promoted earlier. In 2024, DPC, they will be considering all those who are eligible. That is, this is the safest course for you and for him also.
No, my lords, I have come up with a suggestion, Your Lordship. This is my humble suggestion to be for Your Lordship. Because now they don't quarrel over our eligibility. That's number one. No quarreling. Eligibility. We don't have any quarrel over their eligibility also.
Right.
After 1/1/24, Your Lordship. So my humble submission will be that 2023 DPC having been held and finalized, that the public results have not been out, Your Lordship.
The result will be out.
Result will be out, Your Lordship.
Yes.
And 2024 who are not there in 2023, they are also DPC may be held also. That we don't stand on the way. That's what I'm saying.
Yes.
Let me complete it. So both the DPC's results can be out on one day, Your Lordship. And the previous restoration, whatever the seniority is there, that will be maintained, Your Lordship.
No, why? 2023 DPC, let the result come, let that be published.
Yes, Your Lordship. That's what I'm saying also.
And 24 there shall be another DPC.
No, there the catch will be, because if our names are there in 2023, and Your Lordship will find also in that annex.
No, if your names are there in 2023,
yes,
then we will have to interfere with that.
My lords.
If your name is considered
that is sealed, Your Lordship.
And if the court is of the view that your names should also be considered for 2023, and if successful, your name should be published, then we will have to go into that aspect, reservation issue.
That I will take to Your Lordship. Because what the entire thing says, Your Lordship, the entire judgment says that the annexer, issue of that annexer.
Let us understand. Let us understand one thing.
Yes.
Now you will have to accept it that you were wrongly granted promotion, giving the benefit of reservation.
There is no more disputed, Your Lordship, because whatever wrong or right, that has been restored with the seniority list.
Therefore, if you were wrongly granted and they were seniors to you, and in the seniority list, you are junior.
We stand below them.
Below them.
Yes.
Then you should accept this situation that they should not suffer.
No. We are not saying that they should suffer.
Yes,
nobody should suffer.
You want that your results should be declared on the basis of 2023 DPC.
Yes.
No. Let there be DPC in 2024.
Yes, 24 there has to be a DPC, Your Lordship, so that the consideration of the writ petitioners' names can be considered.
And your names.
Otherwise they cannot be.
And your names also.
Because we have already undergone the DPC, Your Lordship. That is my submission, Your Lordship.
Yes, that we will deal with.
Yes, Lordship.
That to that extent, we will modify the entire proceeding of the DPC.
My Lordship, that's what I am submitting, Your Lordship. If that be there, because what has happened, Your Lordship, a person who has already got.
That is the safest course. And they
me on that.
Let me
my lord may hear me on that.
No, definitely.
I will.
Let me complete.
Regarding that course, I have some.
Your Lordship, I just wanted to point out one thing, Your Lordship, because in that recent DPC, for which the DPC is going to be sought to be held, Your Lordship, and by which I want to point out before Your Lordship, at page 16, Your Lordship, may kindly have a glance at that page 16 of my IA, Your Lordship. Is that flag? I think flag F. Flag F, Your Lordship.
Are there any fly F?
Page 16, internal page 16, Your Lordship. Flag F. IA 863.
नहीं बाकी तो कंसर्न
It is not there. Yes, please, what is there?
My lordship. Your lordship finds, I have indicated the shortcomings which are there that could be seen to me, your lordship. That's all. I've indicated in page 6 of my petition, your lordship.
You are referring to what?
Your lordship, there are three shortcomings, basic shortcomings, which I have pointed out, your lordship, in that 2/3/2024 communication, your lordship. There where your lordship found that 184 persons have been now called for the DPC, your lordship.
2/4?
My lordship.
2/3/24.
This year. This year. This year.
2/3/2024.
Yes. 2/3/2024.
What are the shortcomings?
Shortcomings, your lordship finds, while the respondent numbers 16, 20, and 21, A, B, C, I have indicated, your lordship. They have already been promoted to the rank of DCF and have been so protected in para 24 of the impugned judgment. Yet the name of Prashant Kumar Sai, respondent number 16, again appears at serial number 4 of the list.
That can be seen by the DPC.
Number 2 is that Biraj Mohan Mahanti, which appears at serial number 3, he has already retired on reaching the age of
Sir Mishra, you are questioning something
yes,
which has not even begun.
No,
it is yet to start 2024 DPC.
So basic objection which I am there before your lordship. Why here, right? I have spoken from the very beginning, your lordship. I have shown that what is the eligibility criteria.
Eligibility
that is if I am eligible as on 1/1/24, what your lordship says 2024 DPC, I am entitled to be considered.
If we are meant to decide on this point,
yes,
we can hold
yes
that they were entitled to be promoted with effect from a date you were appointed.
My lord, you are appointed. Yes.
We can go to that extent. Which we, if
no, that's right. We are not.
Yes.
I am just conversing that I would have like to read your lordship's mind also.
Yes.
But
So
this is one aspect.
If we are made to decide
yes
on 23 DPC,
yes,
vis-a-vis their right to be considered,
24.
We may go to the extent that their dates of promotion should be altered to the date on which you were promoted. You being the junior. So then that eligibility criteria also the
basic point is the eligibility, your lords. Unless they are eligible,
vanish.
No, unless they are eligible.
Vanish.
No, manager lordship is all right. So for 1/1/24, your lordship, the eligibility will be okay, your lordship. But suppose a person whose name appears here, he is not eligible in 1/1/24, but he will be eligible in 1/1/27. How that name can come in here?
They will reject.
Well, that is
why should we presume this?
No, that is there on record. That's not there on record. That's what I point out. Who have been promoted after my land friends' clients, that is petitioners, your lordship. 2018, their names have come in.
Maybe names maybe
they cannot come here. They cannot come.
The DPC is there to scrutinize. We will not scrutinize.
No, that's right. It's all right. If you also have understood my submission, then I am
yes. Every aspect the DPC.
Yes. Of course,
the DPC is a body of experts,
my lords, and that will also go into the eligibility also, your lordship. Merely because a name has been sent, it will not as it is be considered. Yes, as such,
they will be considered.
It is primary.
Every aspect.
Yes, that is there. That's it. How, my lords, your lordship?
Just a minute. Anything else?
I wanted to just point out that. Please. Let me complete yours. I'll take some few minutes. Yes. Your lordship, then in para 19, that is page 56, the judgment, your lordship. The honorable single judge has referred to that Ajit Singh Januja's case, which has been further again considered in 1999 7 SCC, and he has said Lordship sees the page 57, the quotation, Your Lordship. Quotation part. That is before, that is in page para 19, before para 20, Your Lordship. Top of the page 57, Your Lordship. 57. And let Justice Raman gets it.
Paragraph?
It is in between, it is para 19, Your Lordship, page 57, which starts with the Supreme Court's following observations are noteworthy.
56 is para
56, 19
Para
starts from
19.
para 56. 56. Whenever a question arises for filling up a post reserved for scheduled caste, scheduled tribe candidates in a still higher grade, then such candidate belonging to scheduled caste, scheduled tribe shall be promoted first. But when the consideration is in respect of promotion against the general category post in a still higher grade, then the general category candidate who has been promoted later shall be considered senior and his case shall be considered first for promotion, applying either the principle of seniority cum merit or merit cum seniority. Thus the principle laid down in that is that the inherent seniority between the reserved category candidates and general candidates in the promoted category shall be continued to be governed by the inter-se seniority in the lower grade. There is no dispute over this, Your Lordship, but correct? This is, Your Lordship, there are two aspects which are considered: seniority cum merit and or merit cum seniority, Your Lordship.
Sure, Mr. Let the DPC decide.
Yes, sir. No.
Let the DPC finalize everything.
Yes.
If after that you have any grievance about your non-consideration, inappropriate consideration, placing you at a lower place than what you are entitled to, you can challenge that.
Another round, Your Lordship.
No, there is no.
It has to, and that's the only permissible law, Your Lordship.
We cannot, before the DPC decides, we should not issue the DPC guidelines that this is how you should proceed.
No, I'm not on that, Your Lordship. I'm not on that.
So therefore,
I just wanted to point out that what are the errors which have been committed and which has been going to be perpetuated by the government. If not protected, we are not protected, Your Lordship. That's just my submission. Nothing more, nothing less, Your Lordship. And thereafter, Your Lordship sees, if on the other hand, the proposed promotions are effected, it would be akin to taking away by one hand what was granted by the other. Moreover, even if it is not explicitly stated so, but the logical conclusion of the proposed promotional exercise would inure only to the benefit of the reserved category candidates, that is private opposite parties. But I have pointed out to Your Lordship also that in between the 2023 DPC persons who are eligible, there have also been general candidates. This particular aspect will not be proper. Thus, what could not be done directly by the state is attempting to do so indirectly, which needless to say is not conscionable in law. And then, Your Lordship, para 21, which is the most important para here, Your Lordship, because Your Lordship also has referred to para 21, Your Lordship. How then to go about it? It has been argued by the United States Council that there being large number of vacancies in the rank of DCF, the posts need to be filled up at the earliest for the overall efficiency and smooth functioning of the work of the department. This court finds that the petitioners, having been promoted to the junior branch on different dates in their year 2018, have acquired or will be acquiring the eligibility on different dates in this year itself. Moreover, we are at the fag end of the year 2023. As on 1st January 2024, the petitioners would have acquired the required eligibility. Thus, taking the larger view of the matter and in order to satisfy the requirements of the law of the land, this court is of the view that if it is felt necessary to grant promotions to the rank of DCF urgently, then the government can relax the eligibility criteria in respect of the petitioners. Well, I will pause here for a moment, Your Lordship. This particular observation has lapsed from 31/12/2023, Your Lordship.
Right.
Your Lordship has got it right. Because had there been any DPC, further DPC in 2023,
there would be no opposition by any party to what we are proposing. Don't think
after we hear
because because that will save the save the interest of everyone.
Everyone.
protect the
That's all
everyone.
we want, Your Lordship. That's all we want.
So, yes,
Well, that's just 2.2 more I will just tell to it, then I will finish. Your Lordship. This is, then Your Lordship, in para 23 only, because we are aggrieved against para 23 basically, Your Lordship. In view of the foregoing narration, this court is left with no doubt that the impugned communication under Annexure 1 being a product of arbitrary exercise of power. The word is arbitrary exercise of power. Cannot be sustained in the eye of law, inasmuch as it indirectly seeks to grant the benefit of reservation in the promotional posts to the juniors like the private opposite parties, ignoring the inherent seniority of the petition. We are aggrieved against this aspect, Your Lordship. And if Your Lordship permits also that the 2023 DPC and 2024 DPC can run together and the public results will be out. They have no problems.
23 to the extent it has been published.
Yes.
We will stop. We will stop the DPC from what the DPC has done. 3 published, no further. Further DPC in 2024, they will consider, they will decide. No, or 2023 DPC can be, I don't think 2000.
Because that is already finalized, Your Lordship.
Still cover becomes meaningless. Were senior to you?
No, my lord.
Yes, only 3%. No, 11 were there.
What is, if I may submit,
Yes.
my lord, I'm sorry for.
Finished. All right.
What is being proposed by your lordships is possibly subject to state saying has already been done by the single judge. Para 24 itself, there were 2 interim orders where the single judge.
All right, let us hear the state counsel.
So that has been already done. So what has been actually, what is being proposed by the court, the single judge has taken note of it and taken care of it.
I will only take one sentence I will take. With regard to the eligibility vis-a-vis seniority, I have placed certain decisions, Your Lordship. Because where the Supreme Court says there are 2 different aspects altogether, Your Lordship.
There is no doubt.
No doubt. Yes. But just I wanted to just.
Cannot.
Because these have not been considered by the Honorable Single Judge.
We cannot direct for relaxing of the rules.
No.
If the rules are there, we are bound by that.
Yes.
If we have to do something, we can alter. We can direct for alteration of their dates of promotion.
It's different. That of course, Your Lordship.
Yes. But that we don't want to enter into that dispute in the present proceeding.
Because that has gone against them, Your Lordship, because they say, because it has been held that it is too late in the day to challenge those things now. Those promotions which have been granted to the opposite parties, Your Lordship. They wanted to challenge that or say with regard to that before the Honorable Single Judge, which has been said that no, you cannot challenge it now because it is too late in the day. But the restoration having been made with regard to the seniority list, the previous promotions cannot be challenged now. That is what has been told. And Your Lordship may kindly take note of my decisions, which are also part of my notes, Your Lordship, which relate to again the eligibility, Your Lordship.
The eligibility matter is over. Eligibility matter is over now. If the DPC held in 2024,
yes,
the eligibility question will not be there.
Yes. But my humble submission is that 23 we have having gone through the entire thing and only the results have to be out. That is the only thing.
The results will not be out.
No, will not be out till 24 is over, Your Lordship.
No.
That will be my humble submission, Your Lordship.
Yes.
My lords have already formulated it. At this juncture, I will take my lords kindly to that order dated 3/3/23, which was impugned before the Honorable Single Judge. DPC has only convened. No decision was taken by them. At that juncture, interim order was passed. So, my lord, in all fairness, we should be allowed to go ahead in 24 DPC in accordance with the rules. We are at every point of time, we are complying the rule.
No, but what about 2023 DPC?
The DPC never worked out well.
DPC has been, you have published the results.
No, ma'am.
Let him.
No.
We will come back.
Right.
No, ma'am. That is my instruction is, at that stage, DPC was convened only. At that stage, it has not proceeded further. Nothing further has happened.
Oh, no seal cover, nothing.
No. That's why on the date, on 29/2, I said Yes, I agree with the learned senior counsel that in accordance with para 24 of the order, we are willing to hold the DPC. Because posts are like that.
No, but you may find decisions of Supreme Court which says that if yearly DPCs are to be held and for certain year DPC could not be held,
My lord.
then separate DPCs should be held as if one DPC was sitting for 2023 and the other for 2024. So there are decisions.
Yes.
On that point, I'll find out, my lord, if
Please find out, please seek instructions from the department. This is what we intend to do.
my lord.
And please guide us
My lord.
how to proceed.
Yes. Your Lordship,
My lord,
what my
in
learned friend
this
said.
background, one more sentence, if subject to my lord's acceptance, because I was also hearing all through my lord's. My lord, right or wrong, it's the act. The ORB Act, section 3 says we can go hold reservation up to junior class 1. Thereafter, we cannot. There cannot be any reservation. This is the act, man. There are Supreme Court judgments. It has been also cited. Even my lord reads that para 9. May I take my lords to para 9? That subject to my lord's acceptance. May I take my lord to, it was quoted. My lord, I am reading from page 57. Whenever a question arises for filling up a post reserved for scheduled caste tribe candidates in a still higher grade, then such candidate belonging to scheduled caste tribe shall be promoted first. But when the consideration is in respect of promotion against the general category post in a still higher grade, then the general category candidate who has been promoted latter shall be considered senior, and his case shall be considered first for promotion, applying either principle of seniority cum merit or merit cum seniority. No dispute, ma'am.
Either.
No dispute because yes, it's a fact that 5 years is to be maintained, and the writ petitioners now they are eligible. They have a right of consideration, my lord. But the rule is 5 years. They were to be treated first. They will be treated senior. They are treated senior, ma'am.
Right.
They are treated senior. There cannot be any escape. But suppose, my lords, I am giving an example again, subject to acceptance. Suppose I am a scheduled caste candidate, madam. My friend is a general candidate. I got appointed first, promoted first. After 3 years, he gets promoted. He becomes my senior. But if the post says that, promotion says that 3 years is required, minimum, then he will be considered, but he will not be found suitable. But in the present scenario, as my lords, in 24 everybody is, so my lord may kindly permit us to hold a DPC in 24 and we will go ahead.
My lord, sir, I just want to point out in that miscase.
Now he'll have the right to argue. Your turn will come.
No, just I want to just point out, your lordship, what they say that DPC was not fully completed, your lordship. They have indicated in their affidavit, your lordship, that may please to pass the appropriate order on clarifying its order so and so by the extent by permitting state respondent one to fill up the vacant post of deputy conservatory OFS branch by giving promotion to the eligible officers as per the DPC held on 23/2023. So DPC has been held, your lordship.
But they did not do anything. This is what they are saying.
They have done, your lordship. Pursuant to that, your lordship, the notification came out with regard to 11 persons and 3 only qualified, your lordship. What they say is not correct. They are against their own.
We have not.
Against their own affidavit. Their affidavit.
Seek instruction.
Their affidavit.
Yes.
So far as this issue of reservation is concerned, that is something which they are bringing it on and off. Now, we have given a short note. It's slightly lengthy because the judgments have come in. That is something which would be ancillary to this case, because the question is, if the exercise in terms of M. Nagaraj and Jarnil Singh, if the state has undertaken it, then my learned seniors clients, they have a right to be senior to us. If that exercise is not conducted, then we go into Ajit Singh Juneja 1 category, where we will always be senior to them. So this case basically decides that principle, that point of law, those paragraphs, the single judge has clearly dealt
No,
with
but
that
when
issue.
they were granted promotion
My lords.
by giving them benefit of reservation,
My lords.
did you question?
No. That's a point against my clients. At that point of time, they never questioned. But then subsequently in the gradation list, their names appeared first, and the single judge then relies on Ajit Singh Januja 1, which says that because in now the exercise that they are conducting, their reservation will not be applied. So the moment they don't apply reservation, then catch-up principle will also not apply. So that means for all times to come, they will be ahead of us, even though their entry at the...
You allowed them to be ahead of us, ahead of you.
We allowed them to be ahead of us for a temporary period. Then the government themselves, they applied catch-up principle and made us senior to them.
No, catch-up is different from the reservation and promotion policy.
But the moment they apply reservation, they're bound to apply catch-up also. So that is what the state did in the impugned grade in the list. So this was a peculiar situation where we were in the gradation list, we were ahead of them. But in the promotional exercise, they were being considered ahead of us.
No, but you may find direct decision against you of the Supreme Court, that too in relation to promotion, relation to appointment of a High Court judge.
My lords.
Yes. Where a candidate did not have 10 years of qualification, was senior in the merit list, his juniors were promoted because they had more than 10 years.
My lords, that is of course, then I think the question of merit alone comes. In the question
of merit. We were under the impression that the court has decided against them on the point of promotion by giving them benefit of reservation.
Yes. What the court has done is, the court has said that exercise which they were beneficiary, that was a illegal exercise. But now what falls from your lordship, that now that was just end of 2023. The single judge takes note that people who are senior to the writ petitioner, they have already been allowed by virtue of interim orders. So the court takes the path of least resistance.
No, the court is not required to take path of least resistance.
My lords,
the court is under obligation to decide.
So what the court has said that either you relax, otherwise we are at the fag end of...
How relax? And why?
Well, so far as relaxation is concerned, probably whether that there can be a mandamus vis-a-vis that or not is something which I would bow down to the court. But then the court does take note that we are at the fag end of 2023. You can conduct this exercise afresh in 2024.
No, but why should we interfere with 2023 DPC?
The reason is, if you take 2023 DPC to its logical end, then on one hand, you have given these people promotion contrary to a series of Supreme Court judgments.
Contrary to, you did not challenge, you have accepted everything.
No, at that point we didn't challenge, but here in this writ we did challenge that. In this writ we did say...
When these promotions were granted to them?
They were ranging from 2014 to 2018.
2014 to 17.
Delay and latches was something which was staring at us. But that is something which your lordship knows that there are divergent views. Some say that 6 months, 10 months, 12 months. Some say that if there's an illegal exercise, then the court
question of 6 months, 10 months, 12 months. Even 1 day delay, 2 days delay can be delay for a writ court to exercise jurisdiction.
Discretion.
2 years discretion, not discretion, depending upon the facts and circumstances of each and every case.
So here, if I may show those paragraphs, what made the Honorable Single Judge take a view in our favor, that my lord may kindly see. Now, may I just quickly show the development regarding this law of reservations, because the state also...
Because we started with a presumption in our mind that this relates to some challenge to the promotion granted on the basis of reservation. In the light of the Supreme Court's decision in case of Nagaraj.
That was there. That challenge was specifically there in the writ petition. My lord, may I just show page 10 of my note, which is there. page 10 of my note. Which,
And again, in 2024, if you get promotion, DPC considers your case, again, catch-up principle will apply, you will
the
rank
moment,
above in the merit list.
now in the gradation list, we are senior. Now we are already senior, not in terms of this judgment, but prior to this judgment also we were senior. My lords.
But in 2023, you are not eligible.
Yes. My lords.
And if we hold that you are not eligible and the DPC is to continue, then their cases may be considered and might have been considered, and they would be entitled for promotion from a date before your case is considered in 2024.
My lords.
So again, you will be junior.
My lords. In fact, we would be junior for all times to come, because if that exercise is allowed to continue, that they would not be applying from reservations. That would be on general principles. They are taking eligibility alone. So that would be on general principles. That is what the Honorable Single Judge holds, that if you are not applying reservations, then catch-up principle also will not apply. So then we can never regain our seniority, even though some of them may be several years junior to us.
Helpless, Mr. Shah.
My lords.
Yeah, helpless. We must find some reason to interfere with 2023 DPC.
The reason, my lords, would fall from Ajit Singh Januja 1, which says that a general candidate is always entitled to be considered promotion ahead of the reserve
But
candidate.
because of that eligibility clause of 5 years,
My lords.
and they also have acquired a right because of their promotion with effect from a particular date, which has not been interfered with.
Now, my lord, that's a point against me. The points in my favor would be that the Honorable Supreme Court repeatedly says that unless you conduct these specific exercises, you cannot have reservations in promotions. Here, there was a blatant violation of that particular...
There was blatant violation which you allowed to happen.
We allowed to happen for some years.
And then you could have claimed that we should be given promotion with effect from date. Your juniors were granted promotion. Even you did not claim that.
That has not been done. That's a point against our clients.
But we will consider that.
But my lord, may kindly see the page 10 of our note of submissions.
Have you given?
Yes, my lords. We had given it earlier. Probably it's digitized also. It's there in the...
Yes.
Now, our prayer in the writ petition was to allow us to be considered in terms of all these judgments. And 161192 Indra Shawni comes in. Para 700 clause 6 says that there should not be any reservations in promotion. To get over this, they came up with the 77th, 85th amendment and 81st amendment. That was challenged in Nagraj. My lord had the occasion to deal with Nagraj in Patna in the case of Sudhir Kumar versus State of Bihar.
Can we go into that?
Well, the Honorable Single Judge has gone into that. Now, the crucial question here would be, now in UP Power in 2012, the Honorable Supreme Court says that unless you conduct this exercise in terms of M. Nagraj, there cannot be any reservations in promotions. Categorically, if my lord knows those judgments, if my lord wants, I'll show those paragraphs clearly saying that you cannot have reservations in promotions unless these exercises are done. That is the categorical judgment.
So the latest judgment on that point, I believe, must have traveled from Bihar. Is there any latest judgment on this? Nagraj.
Jarnail Singh, Constitution Bench, if my lord would like to see the Constitution Bench's Jarnail Singh modified Nagraj to the extent that Nagraj said that even for the extent of backwardness, you have to conduct that exercise. That Jarnail Singh took away, saying that for extent of backwardness, you need not conduct that exercise, but for efficiency in administration and others, you will have to conduct that exercise. Jarnail Singh further reiterated regarding the creamy layer. Now, so far as the case here from Orissa is concerned, that my lord may kindly see, it's a part of that compilation. All these judgments are part of that compilation. But Prabhakar Malik would be the judgment which my lord may just. In that compilation, it would be at page 172. I hope my lord gets it.
Yes, ma'am.
Page 172. Paragraph 15. The learned counsel appearing for the state of Orissa has fairly submitted that after the 85th Constitution Amendment by which Article 16(4)(a) was amended, there is neither any legislation in the state of Orissa nor any executive order by the government to extend the benefit of promotion to the reserved vacancies with consequential seniority. And our writ petition was mounted on all these judgments, including this, where we said that you cannot give this benefit to the reserve candidates because you have not conducted this exercise in terms of M. This was again reflected, this admission of the state that they have not conducted this exercise in terms of M. Nagraj is reiterated in para 23. Para 23 and 26. So this takes note of Jarnail Singh also. So in these judgments, my lord would find that regarding the extent of backwardness, no such exercise is required, but the other exercises, that is mandatory. They cannot, and UP power, I'll show in the course of my submissions, UP power makes it clear that if you have legislations pre-Nagraj, that would not be validated. You have to conduct a fresh exercise in terms of M. Nagraj. So what our state here is banking upon is an Act of 75. So then, my lords, here the question which would fall for your lordship's consideration is that you have a series of constitution bench judgments in terms of M. Nagraj.
Shah, just tell us,
my lords,
can we at this stage go into the correctness of the decision of the government to grant them promotion, giving them benefit of reservation, after you having accepted it for so many years?
My lords. There, my lords, then what would be held against my clients would be delay and laches, because we didn't approach the court in time.
Never.
No, in this writ we have. In this writ, we have said that maybe we have not come earlier, but we have come now, at least arrest the illegality. Because what the Honorable Single Judge in the impugned judgment specifically records is that if we are not allowed to be heard and arrest this now, then for all times to come, they will steal a march ahead of us. If my lord wants, I'll quickly show those paragraphs from this order of the Honorable Single Judge. That my lord would see those earlier portions.
It is like if you are qualifying in 2025,
my lords,
then the best way to arrest the illegality which was done with you was to extend the DPC itself to 2025. This cannot be done.
No, that is one aspect. Otherwise, because we had brought in materials before the single judge to show that earlier they have exercised the powers of relaxation. That, of course, I bow down. My lords cannot issue a mandamus for relaxation. But we had brought in instances where relaxation was used.
It cannot be done.
My lords,
if they have done, it's a different matter.
That's their discretion. That's their discretion.
No, there is no, it is not discretionary. That is,
relaxation power is there.
Relaxation power is there.
Yes, yes. It is there. It's not that they have brought, that is something the single judge has said that you bring in. Relaxation power is there. It was not exercised.
Where is that?
That is there. The rules. Writ petition. In the writ petition, the rules are there. Relaxation power is there.
The rules have been provided to us.
Yes.
Yes, the rule has been quoted by single judge.
Rule 15, your
Yeah.
lordship.
See, page,
Yes.
page 26 of the single judge order.
Rule 14.
Rule 14, that is page 26 of the single judge order.
My lords. So power is there, and we had given
23 of my note, Your Lordship.
and we had brought in materials before the single judge to show that earlier this power was used for these kind of exercises.
Well, never.
So in some occasions it was 2 years, 2.5 years. Those instances we had brought before the single.
Yes. Yes.
So the Honorable Single Judge takes note of the law regarding reservation, takes note of reservation, and takes notes of the timeline.
Where is that? Which one?
Your Lordship, page 23 of my note today,
26.
para 14, last para. Miscellaneous, under part 5B, miscellaneous, relaxation.
At page 59 of the impugned judgment, it is quoted.
59, yes.
Yes.
And below that quotation, instances also have been taken note.
So whether commission is a party?
No, ma'am. No, ma'am.
We will see.
Your Lordship, that thing has ended because I have said on 31/12/2023, this issue of relaxation had ended. Because by automatically they become eligible on 1/1/24.
My lords, may kindly see the relaxation instances also have been
See,
taken.
the court has to decide the list.
Correct.
On the basis of the situation as that existed on the date of filing of the writ petitions.
Yes, yes, yes.
All right.
Yes, yes.
So we are required to decide the matter as on the date of
Having the reach.
decide his rights
Correct.
based on that.
Correct.
We will see.
My lords, those paragraphs, may I just show those paragraphs of the single judge where our locus and whether we can maintain this kind of a writ. Because, my lord, may kindly see the competing interests here would be that on one hand, you have a line of Supreme Court judgments which say that you cannot have reservations in promotions unless you conduct this exercise. If my lord wants, I'll show those explicit paragraphs from UP Power, para 86, where this has been clearly laid down. Then UP Power has been subsequently approved in Journal Singh, a constitution bench judgment, which says that this exercise is mandatory. There is no
quarrel over that principle.
What fell from your lordship in the course of the submission is that there may be occasions where the court can also say that you give them from a retrospective date. But I'm not on that. What I'm basically trying to support the judgment of the single judge is the single judge has taken a plausible, a balanced view. And those paragraphs, if I may be allowed, I'll just show from the impugned judgment. Regarding our locus, that my lord may see, paragraph page.
No, where is the question of your locus? There, locus was there.
Locus, they did challenge locus.
Why?
Because
on the ground that you are not eligible.
On the ground that you are not. So, para 14 at page 49, I'll just read that portion out. Having noted the rival contentions above, it would be apposite that this court to refer to relevant facts outset to ascertain how the ratio of the decision cited at the bar would be applicable. As already stated, the petitioner joined as forest ranger earlier than the private opposite parties. But they were promoted as ACF later than the private opposite parties who were admittedly granted such promotion by following the principle of reservation. Then, my lords, the Honorable Single Judge takes note of the rules and takes note of Nagaraj and UP Power, Jarnail Singh, Prabhakar Malik, all 4 judgments. And then, my lords, even affidavit admitting whether this exercise was done or not.
Supreme matter had gone to Supreme Court.
In Prabhakar Malik, which I read out. So what is happening, my lords, in one case which is taken to Supreme Court, they say that yes, we have not undertaken this exercise.
No, we are not saying that.
My lords.
We are saying that this order of learned single judge, whether has been challenged by the estate.
No, man.
No.
We have not.
The estate is accepting the order.
We have accepted.
State is accepting this order.
We are accepting.
So that is a big takeaway. That means now, my lord may kindly visualize. There would be two areas. If the exercise in terms of M. Nagaraj is done, then I'm out of court. I have no case here. If they don't conduct the exercise in terms of M. Nagaraj, then we will have to fall back to Arjit Singh Januja 1, which the Honorable Single Judge has. Because that means now in Single Judge records in several paragraphs, that means on one hand, you don't have this exercise, you are not applying reservations, then these people will never be able to achieve the seniority. That means on pen and paper only you are giving them this. If you want to favor the reserved candidate, then you will have to conduct this exercise. So then
now the things are clearer.
And my lord, here 141, 142 and 144 will also apply of the constitution, because then somebody has to follow the Supreme Court judgments.
142 will not apply.
My lord, 141 and 144 will apply.
142 doesn't apply, it binds us.
41 and 44 will apply.
Yes.
Somebody has to implement the judgments of the directions of the Supreme Court. Here the Honorable Single Judge has tried to balance that out. My most respectful submission.
All right. Thank you. Thank you so much.
My humble submission, one line, your lordship. Lordship, what I have stated, because I have not taken your lordship to the distance which I have relied upon. Your lordship may kindly go through that only, which says that eligibility and seniority, they are two different concepts altogether and two different.
There is no doubt about
it. That is there. And recent judgment also by your lordship's predecessor, I have also given one then. There also they have said the same thing, your lordship. That also may kindly take a note of.
A note.
My lords want me to file a written note on that instruction, my lord, whether we have.
Affidavit is already there. Affidavit is already there. Para 7 of them.
Last portion of the impugned order, the court takes note of the leave that was granted for those senior people to be promoted. So what was being proposed by your lordships is also there allowed by the Honorable Single Judge. 2023 DPC, people who are senior to us have been allowed in the impugned order itself.
Now we will not open our mind. We will not open our mind now anymore.
Well, we are here to assist you.
All right. So judgment is reserved. All right, today we are not reserving the judgment.
Well,
we will reserve the judgment on the next day. In the meanwhile, you seek instructions as to what, or you file an affidavit.
Yes, ma'am.
As to the stage of the 2023 DPC. All right.
And your lordship, I will be just permitted, if I am permitted, your lordship. And if they go ahead with the 2024 awaiting without waiting for your judgment, then entire thing also goes topsy-turvy, your lordship.
No, we will decide as soon as it is possible.
Yes, sir.
Discuss matter on Tuesday for further hearing. Stop. In the meanwhile, the court expects the estate to file a short affidavit stating the stage of the DPC pursuant to which notice?
3/3/23, your lordship. Annexer 1 to the request.
DPC pursuant to the notice dated
03/03/2023.
2023. The file short affidavit.
Yes, Mallards are calling it on Tuesday.
Oh, Wednesday. Oh,
bless.
That's Wednesday. 18th.
Wednesday.
18th has some difficulties. Can it be Tuesday or something?
Tuesday, it will be too soon.
Okay.
Thursday, we can.
Okay.
If you have difficulty, then we can.
Tuesday, Wednesday.
Wednesday.
We are all grateful to you.
Grateful.
2 p.m.
Thanks for your presence, Your Lordship. We are grateful to your presence, Your Lordship.
I always say that this is our duty.
Right.
Yes. Who is there in item 53? The matter was mentioned for. All right. Call comes.
Item 21.
Item 21, sir.
Please, my lord. Well, I beg to appear in 21. It's
Item
a very
21.
short point. Can your lordships hear me, my lords?
Yes, Mr. Singh. Yes, Mr. Singh.
I'll be very brief, fellas. It's a very short point. Yes, it's a very short point, fellas. I'll be very brief. Let me give your lordships a 1-minute summary and then read some parts of my application. Fellas, I am a successful resolution applicant who has come in and brought out of distress and erstwhile as an ex-CD, an ex-promoter, and succeeded in reviving with huge employment and benefits to Odisha. Now, the old promoter, the old company, had some few violations of regulations relating to user in forest or semi-forest areas. Now, that was already under regularization, and there is already at various points of time and in principle for regularization of those slight encroachments without which the whole factory can't run. After I took over, some time was given, but ultimately, an order was passed by this court that no, now there shall be taking away of land and prosecution and penalty and all the usual things. Subsequently, I had the privilege of appearing before your lordships, and a detailed order was passed on 4th September 23, which gave in detail all the steps taken, how it is a salutary public interest project, and that the forest clearance is on the cusp, on the edge.
Which is the date, Mr. Singhi, you are referring to? Which date? 17/5/2023.
I'll just give you the order is passed on 4th of September 23. Give me just 1 minute more, then I'll read it. Just 1 minute. So that order says that now, given all this, given all the positives, and that I am not to blame, it's the earlier one who was to blame. I am giving you, Mr. Singhvi, 6 months from 4/9/23 to get that permission. To cut a long story short, that those 6 months expire in 2-3 days' time from today. A lot has happened, a lot has been done. But the meetings of the FAC, over which I have no control, happen hardly once a month or once in 6 months. It is likely to happen in the whole thing will be over likely within March and April. So this application is to seek time for 3 months more. That's the long and short of it. Now kindly turn to the application. I'll take 5 minutes more. That's the summary. Now turn to the application IA 3265 of 2024, which is possibly in your lordship's convenience volume at page 32.
Yes, it is there. Page 32 of IA 3265.
That's right. That's right. Now, if your lordship will just turn to just a few paras, I'll be very quick. I'll just do some speed reading with your lordship's kind permission. Now, this is the first para. Applicants are constrained to file the present application being extension of time granted by this honorable court by the 4th of September order in respect of 35 hectares of its project land for thermal power plant as my forest development permission and the active consideration of the MOEF, and regularization is expected to be processed in the coming weeks. Now, para 2 gives an important fact. Page 2, para 2, the second line, already in principle approval had already been granted. So this is nothing, it is not some irrevocable major thing. In its 89th meeting on 13/6/23 for regularization.
Where is it?
Then
Where are we reading,
para 3 and
Singh, we have missed somewhere. We are reading your prayer portion of IA number 3265. You are referring to what?
No, that's the prayer. Now come to para 1 of that application, which is at page 2.
Sorry.
I'm very sorry. I didn't realize the lordship is not reading. Page 2, para 1. Just a few paras I'll read and that will make everything clear.
Yes.
Everything is quoted there. That the applicants are constrained to file the present application, being extension of time granted by this court on 4th of September for processing of the application called Forest Diversion Proposal by the Ministry of Environment, etc., in respect of 35 hectares for thermal power plant as my FDP is under active consideration of the MOEF and is reasonably expected to be processed in the coming weeks. Para 2. While passing the order of 4-9, this court considered that an in-principle approval had already been granted. This is very important. On 13th of June 2023, I'm reading para 2, page 3, Malas.
Yes, yes.
Then, Malas, para 3 and 4 quotes the order. Come to para 4. Your Lordship need not go to the order. The operative portion is here, but of course the order is also there. The operative portion of this, and I had the privilege of appearing in the Odisha High Court for this order, so I know about it. We have appreciated the submissions advanced by learned counsel for the parties and also taken note of the explanation provided under section 32, capital A, bracket 2. The words "and action against the property of the corporate debtor in relation to an offence" would include the attachment, seizure, retention, or confiscation of such property under the law applicable to the corporate debtor. The word "include" is used under subclause 1 of the explanation. The word "action against the property of the corporate debtor" is intended to have the widest possible amplitude. There is a clear nexus with the object of the code. May I digress for 30 seconds, fellas? One of the points I had pointed out was that new section has been inserted by Parliament, 32 capital A, precisely for new persons like me who succeed as successful resolution applicants and come in. They can't be prosecuted or punished for the misdemeanors of the previous person. The previous person may have some problems. I come as a knight in shining armor. I'm always giving money. Suppose he has a money laundering case against him. Suppose he has a CBI inquiry against him. 32 capital A, enacted by Parliament as an insertion into the IBC code, exempts the newcomer. That's it, what is cited in your Lordship's order. Now come to para 18. We have seen that the forest diversion proposal has been, para 4 of the application, quoting para 18 at page 3 bottom of the application. We have seen that the forest diversion proposal has been considered and recommended by the REC for the forest, as already noted above. So in principle, recommendation and approval is already there. We have also noticed that a total forest area, including the encroached land over 35 hectares, is the subject matter of the diversion proposal for leasing out to the applicant, qua opposite parties. So it was almost done. Time is being taken, and these things take time. That's the nature of the beast, if I may say so. That's the nature of the bureaucratic process. We extend the time for execution of the order by 6 months from today. In the meanwhile, the final order accepting the forest diversion proposal and leasing out of the land by way of regularization is passed in favor of the applicant. Our order, that is the earlier one, Manas, of 14/8/23, shall be automatically restituted for execution in the similar terms as reflected in the order of 14/8. That is, Manas, it shall be executed with penal consequences. The state opposite party shall, in that event of failure of the applicant to produce the order of regularization and leasing out, take immediate action to vacate the encroached forest land. The prayer is rejected. Then, Manas, we are at the last stage in para 6, if your Lordship. First, fellows, see 5 and 6, then more or less that will be done. 5 and 6, fellows. A major component of FDF, which is identification of equivalent area of non-forest land for compensatory afforestation, has already been completed. I'm giving your Lordships bullets about what is done already. In this regard, the Orissa Space Application Center, by so-and-so November 23, informed DFO that the DGPS survey maps and data showing compensatory afforestation land in Rampela village under Tehsil has been verified and is certified at a level of 95%. In fact, the principal conservator of forest, with a letter of 22/11, so a lot of things have been happening, Wallace, forwarded his recommendation to Deputy Director General of Forests for necessary approval under Section 2. The applicants verily believe that Deputy Director General in January 24 further recommended the matter to MOEF. As of 26th February, that is last month, Wallace, last few weeks ago, the Assistant Inspector General has directed by letter the regional office to inspect the area proposed for diversion. Well, unfortunately, I understand, Wallace, it takes time. It should not take time, but it does take time. It's a bona fide situation. A few weeks more will solve it. Then, Wallace, it is pertinent to note that presently the approval for FD is in its last stage of being considered by the head office of the MOEF, and thereafter the FDP will be placed before the FAC. There are the 2 steps left. Para 7. The FSC meetings are held once every month in order to take up different forest diversion proposals. This is the reason for the delay. A meeting once a month, but all over the country, the applications come by rotation, not only mine. from different states for consideration of grant of forest clearance. The last such meeting was in February end, and the applicants verily believe that it will be held sometime in the month of March, and they believe that it will be taken up for consideration. Meanwhile, the period has expired. Well, the rest of the paras are about all that I have done. Para 9, I have come in and I have taken over, and all the good I am doing, all the power I will generate, all the industrialization I will do. Para 13 is the breakup of the land. Your Lordship is concerned only with 35 hectares of revenue forest land.
Yes.
Para 14 is the history prior to me. The story starts from 2010. And these issues were pending, in fact, with the earlier CD, but it was delayed in between because he spent 3 years in insolvency. When it got taken up, therefore, he did nothing at that time. I came in and I have fast-tracked it. I will not take your Lordship's time reading it. Para 20 to 21, tell your Lordships why the delay was because of IBC by the earlier chapters. The consequences of this plan are very beneficial is at para 29 and 30. If your Lordship will glance at that for 5 seconds, But
Mr. Singhvi, should we ask the state or the opposite parties to
I would submit
take instructions?
Your Lordship, may I submit? The instructions in this kind of matter, of course, subject to my Lord's kind discretion, would be of very little value. The order of your Lordships is detailed. Now, in that order, it needs only without prejudice, a extension of 3 months is what I've prayed. Nobody really can, it's clearly your Lordship's discretion. It is not a willful default. It is not a person who's in contumacious disregard of your Lordships. It is not a person who's deliberately doing it. Each of the facts I said is involuntary, beyond my control. And I have no doubt it is in my interest. So I will again sit on the heads of whoever I can as fast as possible to get this thing cracking in the next meeting and the next meeting. It's not in my control. I can only push and push. Therefore, I would request your Lordship, if your Lordship considers 3 months, and I've deliberately made it 3 months because our people also know that if they cannot constantly sit at the doorstep and get it, then they are the losers. So that's all I'm saying this.
Yes. Yeah. Yes.
My Lord, so far as the state role is concerned, it is only confined to within 6 months, they cannot.
One sentence for. I'm sorry, my apologies.
Yes. Yes, Mr. Singhvi. There's some connectivity issue, Mr. Singhvi, with you. At your end, there is some connectivity issue, Mr. Singhvi.
Can your Lordship hear me? Can you hear me?
We can hear you, yes.
Very well, Malas. Very well. Let him argue. Yeah, one sentence only, 31(4) of the IBC code gives me 1 year to seek approvals. I was just pointing it out, Malas. That's a section because IBC involves newcomers and ex-people, the ex-series. So under 31(4), if read literally, if your Lordship's court orders are to be ignored, I have time till 17th May. But I'm not saying that I am bound by your Lordship's court orders, so I'm obliged to come to your Lordship to seek an extension, which I'm seeking for 3 months, so I don't have to come again and again. Very obliged.
Thank you.
Your Lordship may see page 47, para 19 of the order. The state role is very limited. The direction is like this. The state opposite parties.
No, this application has been filed for seeking extension.
Extension to get the clearance from this MOEF.
Yes.
So 6 months time was granted. Now he seeks 3 months more time.
So do you have any objection?
No, I have no objection because
anyone has any objection?
That MOEF is there. We have because
who is for the Union of India?
I am happy.
Do you have any instruction or?
We have seek for instruction. We will file it. We file an objection.
Will pass order on Tuesday. Tuesday we will be passing orders.
Very well, Malas. Very well.
Status quo is on today. It has been reflected in the order. April 4/9/23 in para 20, page 9. The till expiry of the extended time, the status quo is on today shall be maintained in respect of the forest land.
No, we are maintaining status quo. There is no issue on that. We are maintaining all that.
It's not maintaining. We have received some information that
you are appearing for whom?
For petition.
All right. Make your submissions on Tuesday. Third, Mr. Let's just matter. on Tuesday.
Thursday.
For learned Deputy Solicitor General of India to seek instructions and address the question.
I'm sorry, I'm the one. Can it be on Thursday, Malus, instead of Tuesday?
Thursday, all right, Thursday.
Obliged, deeply obliged.
Lord, in fact, a little line from my lords suggesting to them to take instructions to hold the next FAC meeting will resolve the entire matter, Dr. Singh
We will see
also
what
suggested.
We will see.
Grateful.
We will see that.
Grateful.
We are deeply obliged, Malus, deeply obliged.
Yes.
Item 42 is not a jail protection. Can be extended.